I don't know how much they already spent on that. I don't know.
I got locked up.
Everything on a data.
Especially with the disc, you know.
I know it's just for what I'm. I don't use it. I don't have it. Goes for that. He figured out what happened.
Registering here now.
So what you do with the just, I believe.
Okay.
What they do is describe it sometimes. They put.
There is no.
Oh, when you see she's like, yeah, I accidentally put his own.
I guarantee that.
And then we got the responses like.
You're going.
I guarantee there's probably lots of people that register twice. Both unique IDs is correct voting. What do we call that?
We're trying to.
Yes, my request.
I want to, because you're in the.
Just blame on him. He does it in the background in that fashion, in the way that you guys do. First guy today, so you get here. Admitted that he voted twice. He said, I had somehow I'm not very. Unique IDs. So that one, that second one, easier. Heck, I could have voted. My heart.
We got the three.
All right, reports from the order.
All right, thank you all. Please be seated. All right, good morning. We are here for a notice for a final hearing on 25CV013635. Brant Meadows is plaintiff versus Brad Raffensperger in his capacity as Secretary of State as the defendant. And so we've got some housekeeping to take care of. Let me first start, see who we have here on behalf of the plaintiff.
Yes, sir. Brant Meadows, plaintiff pro se.
There we go. All right, welcome, Mr. Meadows. And who do we have on behalf of the defendant?
Elizabeth Young from the Attorney General's office, and taking a you from our office as well. We also have Shauna Hill from the Georgia Secretary of State's office with us.
All right, welcome. And so looks like we've got a court reporter here and ready to working away. Anything to take up on that issue? Everyone, they've arranged for a takedown among the parties?
Yes, Your Honor. We had both scheduled a court reporter. We realized we can only have one. Mine wound up in the hospital today, so we're good to go with one single.
Okay,
And
so you've
then-
agreed to share costs and takedown then?
Yes, Your Honor.
All right. There we have it. Okay. So the next thing we've got to take up is for this particular hearing, we did get a Rule 22 request filed by Mr. Ted Metz. And is there a Mr. Metz here in the courtroom today? All right. Seeing none, then that'll be considered moot. And I'll note, though, that in keeping with our usual practice, the proceeding is being live streamed at the moment for any and all who want to tune in. All right. So with that, is there anything further we're waiting or need to address before we get into the merits on behalf of the plaintiff?
We have some preliminary motions that we'd like the court to address before we have a motion to dismiss, and then they're plaintiff would file a conflict of interest motion, preliminary injunction motion, but that's prior to this hearing. But we're prepared to address it if there's anything.
Okay, and I'll note I've reviewed the docket as well as all the pending motions and the amended complaints, so I'm aware of what we have to tackle today and get through, and just seeing if there's anything else outside of the docket that has come up since. Anything on behalf of the plaintiff?
I'm ready to proceed to
Okay.
opening.
I filed a motion to quash. There was a notice to produce that was filed, but it was not properly served. We filed that on Friday. I don't know if it's made it to the document.
No, if you have another copy of that, that would be appreciated. I've not seen that. Sure. And does Mr. Meadows have a copy? All right.
So like on Friday,
10:37 PM Friday, I received. Thank you.
Okay, so what I think it would be the most efficient thing to do here in terms of the order of operations is to take up the motion to dismiss, the amended motion to dismiss, because that might narrow our focus on what we actually need to hear evidence on today, if anything, and which of these other related motions are relevant, if any. So with that, again, as I mentioned, we've got the original motion to dismiss, to which Mr. Meadows filed a response, reviewed that. We've got the amended complaint, to which the defendant filed a renewed motion to dismiss. That was a little more recent, so I didn't see a filed response to that, Mr. Meadows, but we are here today and we can hear argument on all those issues if there's anything substantively different. But taking your complaint and the counts you have in there, we have the defendant had filed that motion challenging each and every count. And to that end, I think some of these do deserve some discussion here. Some maybe a little more straightforward than others. I want to start with, again, I'll just pick off which I think may be one of the more straightforward ones, is I think it was count 4 of your amended complaint, which deals with an open records officer. And so I turn to count 4 of your complaint, and the defense has responded that this fails to state a claim as a matter of law, and you had your response to your motion to dismiss. And so let's just start right there, whether this is a valid claim. So you assert in your response to the motion to dismiss that essentially by law, an agency must designate an open records officer. Do I have that correct?
Your Honor, in my motion, I believe the open records officer or custodian, or if there's one named by the statute, and the plaintiff asserts that there was an open records officer that is cited in their standard operating procedures that was provided voluntarily by defense on a January 29th response to my October 10th open records request. And so there is identification also through Exhibit G relative to that, Your Honor, where plaintiff was at the Secretary of State's officer, specifically asked for a custodian, asked for an open records officer. And to that point, that's normally with other agencies, there is a point person, and that is part of my frustration, is trying to identify a point person who can be responsible. And so that is the nature of that.
I guess what I'm trying to focus in on though is it your belief that they have to designate someone? If they had chosen not to, then they had nothing to tell you in response.
My knowledge of the act itself identifies a custodian, and that's what I went in and asked for was the custodian. Those terms can be interchangeable. But again, if they have, according to the act, identified an open records officer, then that would be applicable. I believe the Secretary of State does have an open records officer, but I have never been given that name other than they identified that there was one. Mr. Spearman, Mr. Center did. They identified her as Joy. I don't know beyond that. I'm sorry, plaintiff does not know beyond that, Your Honor.
You can use first person. Don't worry about that.
Thank you.
I'm just, again, I'm trying to this I didn't read in the complaint. As I read your complaint, you said that you think that they do not have one. So you think that they do have one?
I now do believe that they
Okay.
have one. At the time, I was under the impression that they did not have one, but I believe that someone named Joy is their open records officer, and I'm just trying to find that out.
Okay. And where did you come across the name Joy?
That was provided by Robert Center and Mr. Spearman of the office when I made a personal appearance on September the 30th. That's explained in one of my exhibits also. Also in their standard operating procedures, if you write a check for an open records request, it states that you will write it to the open records officer. So the standard operating procedures presume that there is an open records officer.
Okay. All right, let's explore that some more. So, Ms. Young, I don't know who's taking point on this. Okay, so I guess the first question would be in the motion to dismiss. I think you say that there is one. I think in perhaps some of the later filings, that's not quite as clear to me. So what would be your position today of whether there is an open records officer designated by the Secretary of State's office?
Well, certainly on the Secretary of State's website, there is an indication that all open records should be sent to the open records officer. But the statute, as you noted, does not require an agency to designate one. The exact language is that agencies are not obligated to. And to the extent that, well, let me take that back. The Open Records Act only requires that agencies identify the open records officer when requested. And as Mr. Meadows has said already here, the open records officer was identified. He has a name. I think the Exhibit G, he asks additional questions of employees of the Secretary of State's office, such as, where is she? What is her office? Et cetera, et cetera. And I will say also that the open records email is also available on the website. And Mr. Meadows has not alleged that he has had any trouble submitting emails and open records requests via email.
All right. So your position is Secretary of State's office has designated an open records officer who is a specific person.
That is my understanding.
Okay. And, just looking at the statute, that's someone that they filed notice in the Fulton County Daily Report, the legal organ of the county, made it official.
So I believe that in the past, there was a notice sent to the legal organ that identified an open records officer, generally, capital O, capital R, capital O, but not an individual necessarily.
And in terms of prominently displaying that designation on the agency's website,
Yes.
you mentioned in your motion that you think that is satisfied through the open records portal?
Yes. So the designation appears actually on the actual open records webpage on the Secretary of State's website under the tab process to file an open or submit an open records request. And Your Honor, I did inadvertently omit a second hyphen in the URL provided in the brief, but it does appear under that tab, which would obviously funnel any would-be requesters to the open records officer and then also the portal, which contains the open records email.
Okay. And I think I'd found the right tab. If we need to perfect the record on this, we can print screenshots or whatnot, but I've got it pulled it up here. And I think I've got the designation selected of process to make a request. And it says all open records requests must be made to the open records officer. Please use the following link.
Yes.
And I click that link. And it's got another screen here that talks about a new request, a search request, a track request. But it doesn't really talk about an open records officer anywhere on there. So how would you say that this website is prominently displaying the designation if you have in fact designated an open records officer?
Well, so the notice indicates that it's the open records officer, capital O, capital R, capital O. And under the tab itself, it indicates that all records should be submitted to that individual, that particular email inbox.
Okay. And the statute reads, in the event an agency requires that requests be made upon the individuals identified. And so I mean, this is identifying the individual just by calling somebody we don't know who an open records officer?
Well,
How so?
I'll admit that the Open Records Act is a little bit gray in that area, but there's really no indication in the plain language of the statute that requires agencies to designate a specific individual by name on the website. And for policy reasons, I can imagine why an agency might choose to select or designate a position, in the event that employees move in and out of that role. They don't have to then continue to notify the legal organ if, in fact, there's already an email that is used and has historical access, et cetera, et cetera.
And so I can understand why you might not want to put a specific name on there. But if the statute is saying you have to identify this individual, how else would you identify someone if you don't put their name?
Well, I believe the language is that upon written request or verbal request, and here Mr. Meadows has alleged that when he did request that information, that was given to him.
I mean, it also says shall prominently display such designation on the website, right?
Right. But I'm not aware of any case law
Okay.
that, interprets what prominently displays mean.
And it may not be that there is any yet. No one's challenged the specific aspect of it. But I mean, as I understood it, you've got a separate component of the statute that says, even if we don't have an open records officer, we can require that people make all these submissions through the portal. So is there any reason why this portal is affected at all through the designation of an open records officer? Meaning, even if you didn't have one, this would still be a proper process, this portal.
Well, I believe that the statute allows agencies to select different methods of transmission of open records requests. So as long as they also include email and, faxes as if it's used in the regular course of business. And so that would be, I believe, appropriate under the act that they also have a Just FOIA portal, since that's an authorized method of transmission.
But even without designating an open records officer, you could still use this portal and direct that all requests go through this portal.
I believe so. Yeah.
All right, but for today, for this complaint, the Secretary of State's concession or admission here is that there is someone who has been designated an open records officer.
It would be just the general position, open records officer, yes.
And that's through a position, not a person.
I believe that the notice says open records officer without identifying an individual by name.
And in theory, that position could rotate every day. Someone else could be that person every single day.
Yes, but there is a specific open records email, which is monitored. And so, all open records requests would be then sent to that particular email.
Okay. All right. And Mr. Meadows, anything else you want to weigh in on this particular claim?
Yes, Your Honor, you capture the circular motion of that. And normally this is a role reversal. I usually would work alongside the Attorney General's office if we were dealing with a non-state actor, but in this particular case, it's a little bit unusual. But I use the Attorney General's officer as the exemplary way to handle it. Jotana Tulloch, she's very clearly identified. She gives you an email. I've worked with her on issues. That is part of the issue that we're here with today, because plaintiffs looking for an individual that you can go to and have responsible. And that's the heart of the issue here. We shouldn't be in here. We should have already been able to work these things out administratively. And that's part of the reason why. Even in the link, by the way, that I was provided in that renewed motion to dismiss, when I went to a dead link. But also, and I had filed a subsequent motion, or I'm sorry, notice also that included how to make an open records request that was provided by the Attorney General's office. And it gives some additional insight into what that is. That's the series.
Sure. So practically, let's say they had on their website on the portal saying, here's the portal you have to use. And our opens record officer is John Smith. And he's employed with our office. Here's the email you have to use to reach him. How would that have changed anything that you did throughout this process?
Well, Your Honor, I would be able then to have a point person, somebody who was responsible and accountable to me. And if it is that revolving door every day, then you're trying to figure out a way to get resolution. And it just makes it virtually impossible if they do have an open records officer. And even that goes back to the heart of it, because just simply trying to identify who is the person who handles your open records requests down here. That was left as pretty much as a general custodian. I was never able to identify who that was. Like I can only use the Attorney General's office as a comparison, and Joe Tulloch clearly identifying who that open records officer is. If you have an issue with open records at the AG's office, you go to the open records officer.
So would it, I mean, but your point of contact would have essentially been the same. If they say you can only contact him, this person hypothetically through email, it would have been the same way that you're making these requests. You just think that as a matter of policy, there may have been a more consistent response, or you may have gotten more of a dialogue going. Is that fair to say?
Yes, Your Honor, and that goes to the heart of the standard operating procedures, that they operate contrary to what the act is, and particularly relative to this issue about the open records officer.
All right, but all right, noted. But the last thing on this is that your response says that pretty much black and white, that every agency shall have the right, excuse me, shall designate someone, that they're required to designate an open records officer. That's not accurate, right?
I'll concede that, Your Honor. Yes, the act states custodian is the proper terminology there, and sometimes those will show up interchangeably. And so the word custodian is what I see in the act is identified.
They do not have to designate an open records officer, right? And you could, by the way, there's going to be a lot of back and forth. You can just stay seated the whole time. But they do not have to designate an open records officer, right?
That is correct, Your
Okay.
Honor. They do not.
All right. So the issue of set out in the complaint, as I see it here with that concession, is that a specific individual wasn't adequately identified by the Secretary of State. Now that we've hear the concession or admission rather, that there is such an individual in the loose sense of the word. They're saying it's more of a position, not a person.
Your Honor,
And right, so that becomes more an issue of statutory interpretation, to which, as I hear it, there has yet to be any clarity from our appellate courts.
well, Your Honor, I apologize if I can correct the record. I just received correspondence from my client that they did not, in fact, designate an open records officer.
Okay, so we're still kind of figuring this out in real time.
They've opted not to. Yes, Your
All
Honor.
right. Well, I guess we're just going to, at this point, leave that as a live claim here and allow anyone to present evidence they have on it. So I'll deny the motion to dismiss at this stage on this claim, and it might be worth putting forth whatever evidence you have in order to sort through this. All right. Again, in an attempt to kind of narrow the issues here, we had in count one, the contention is that requester is permitted the right to physically inspect records. That the statute repeatedly throughout uses the terminology inspect or copy, or inspect and copy, meaning the requester at their prerogative is able to say, no, I get to get in there and look at them, put my hands on and my eyes on the actual original copies. And so as a matter of law, whether that there is a right to physical inspection. And so we got a response on behalf of the defendant on that point. And Mr. Meadows, is there anything raised in their motion or anything else that you want to add onto that?
No, Your Honor, other than the act itself clearly and explicitly states that that is the underlying part that the General Assembly put in there for the verification. Secretary of State maintains they trust us, and the General Assembly identifies that that is the mechanism. The defendant relies on an exemption that they use as a blanket exemption that would be specifically used in a line by line, item by item, but not in that, because if that's the case, Your Honor, then any agency could decry that anything that is electronic would not be subject to personal inspection. And I realize that there are redactions perhaps, but with modern technology, that's not an issue anymore to be able to go look at a screen. The plaintiff had belief that there was a missing open records request. His plaintiff's own open records request was not provided in a log that was provided that reportedly was told to be comprehensive. And so that's what the nature of the inspection boils down to.
All right. Follow-up for defense here. So I just want to make sure I understand the motion argument here. Is it that a physical inspection is never required full stop? Or is there some scenario where a requester would have a right to a physical exemption? So, and for that, I'm looking at B1B.
Mhm.
And there's a sentence there, notwithstanding any other provisions of this chapter, an agency may, in its discretion, provide copies of a record in lieu of providing access to the record when portions of the record contain confidential information that must be redacted. So reading that sentence, is that implying that although although it's talked about inspection or copying or inspection and copying, would that sentence in context imply that the only scenario where copying is permitted would be when you have to deal with confidential information? Meaning in all other instances, inspection can be a right insisted upon.
I don't believe the act mandates physical inspection. I believe that Georgia courts have interpreted the Open Records Act to just simply allow reasonable access to records. Now, whether that's a physical inspection or producing copies, I think is within the discretion of the agency. So I believe that the agency has the discretion to choose whether a physical inspection or receiving copies is appropriate.
And so,
May I add one thing?
sure.
In any event, these records do contain confidential information. You would not necessarily think that would be the case, but I have examples here where people have submitted open records requests where they say, I would like my final judge disciplinary action from the nursing board. My name is such and such, date of birth, such and such, social security number, such and such.
Sure.
Which is why it would be a problem to let someone just look at these things come up on a screen. We don't know what's going to come up on there, but people on a not infrequent basis will put information in the description of the request that requires redaction. That is one reason why these logs that Mr. Meadows is seeking actually do take quite a bit of time to produce because, somebody at the secretary's office has to go through each and every entry looking for these types of things to redact the confidential information. So I don't think the court needs to
Sure.
reach the issue of whether or not inspection is required in situations that don't include confidential information because these do. And
So
these records are
every
not
request
gonna be
aspect that
stolen.
he made, you believe would fall squarely within that provision saying copying is okay as long as because it involves confidential information.
Because if they pull the log up on the screen, it may or may not contain confidential information, but the secretary has an obligation not to publish people's private information to the eyes of, a member of the general public that wants to see what's going on the screen.
Was it the response here that each open record request that was provided in response had to be redacted in some way, or each one of them had confidential information?
Not every request includes confidential information, but if you're sitting here pulling up a log on the screen and it's populating,
for them to see what the results are and determine whether or not there's confidential information, that needs to be done outside the eyes of the public so that when they do come up with these hits for redaction, they can provide the redacted information then to
Right.
the requester.
And that makes perfect sense. I'm just trying to figure out how to apply this sentence, which says you can provide copies when portions of the record contain confidential information that must be redacted. And when I read that, that implies that if they do not contain confidential information that has to be redacted, then that sentence isn't as conclusive.
Well, I mean, that would require a level of technology that the Secretary of State doesn't have to know before the information populates on the screen.
No question. There has to be, a manual, in-depth inspection, or review by the Secretary of State's office. Let me get my terms straight. But what I'm getting at here is this sentence implying, if you will, that if after that review turns out that this doesn't need to be redacted in some way, that then we can't rely on that sentence to say copies are fine because after the review determined there didn't need to be anything redacted.
Well, by the time that has, my understanding of what Mr. Meadows wants to do, by the time that determination is made, he's already seen the information. So, you would be allowing a member of the public to come and witness the possibility of confidential information without giving the secretary the ability to protect the public's personal and sensitive data from him.
The possibility I'm just framing here is before he's seen anything or physically inspected anything, the Secretary of State has first reviewed it, decided whether anything needed to be redacted. Turns out it was no, then is invited for a personal inspection. So that there is still that option for a review process. Why is that foreclosed by the statute? Is that not required by the statute?
I think that's a hypothetical that's outside the facts of what was happening here. But I think the court would be correct that in such a circumstance that might be permissible. But that has not been our experience with the specific requests at issue.
And why is it outside these facts if the agency here did do that review and, as you said, found that some of these responses did not need to be redacted in any way?
Well, so he's asking for a log of all
Right.
requests. So, yes, some of the requests on there may not be redactable, but if 1 out of 10 on a log is redacted,
Okay.
that log still is redacted.
All right. I see what you mean. So it wasn't that because what was provided was not each individual request, it was actually a summary log that y'all created. You're saying it falls under it in entirety.
Right.
Okay. All right. Mr. Meadows, anything you want to add in there?
Yes, Your Honor. As a general practical matter, the physical inspection is not needed unless you believe that there was an omission. I believe that there was an omission, which is why the very specific wording of September the 23rd, plaintiff has done thousands of open records requests and never had to litigate. The Attorney General, the Governor, the Inspector General all provide freely the information that I've requested. And the underlying request that I typically make is not the one that's September the 23rd. It says, please provide the log or summary. But in the event that that does not exist, I want to look at the underlying actual open records request. And back to the point earlier, I'm wanting to work with somebody on this. That's what the plaintiff wants. I want that. But the verify is the General Assembly portion that they put in that allows for that. Technology in this day and age, oh boy, I don't believe that applies. Also, the statute talks about that the electronic production must not erode. It talks about eroding, the verification. And so the Secretary of State uses this as a blanket. I'm sure there are instances, but I'll point to the standard, to their standard operating procedures. Nowhere in the standard operating procedures is there any methodology at all described for personal inspection. It simply does not exist. And so that, I believe, identifies the blanket exemption here, and the plaintiff's own record that he had submitted that he wanted to verify that they actually had and received surely does not fall under that exemption because the plaintiff authored the very email open records request he's asking to see.
All right. So on this issue as well, because I think that the nature of the document that was requested and what was actually produced is going to be determinative, and that's an issue of fact. I think that has to make its way forward and can't be decided as a matter of law at the front end. Let me turn to count 3, which is focusing on the costs, the reasonable charge requirement. And to this, Mr. Meadows, you were, as I understand it, quoted $30, right?
That was for a monthly log, Your Honor. Previously, in December 2023, plaintiff can testify that the Secretary of State provided freely, as do all the other agencies. The requests that are made are so de minimis and so quick that they were designed to be that way so that we can get in, we can get out of here. And even in the case of Jotana Tulik, because she may not receive one every day, but she receives mine, plaintiff worked with her to say, look, here's a different crafting of this open records request that you don't have to respond to what I've already submitted there. But if you have another one, same thing, work with Nigel Lang at the Inspector General's office, which goes back to the heart of having that point person, Your Honor, just trying to resolve these matters for all Georgians to make it work.
I understand that. I've got to take it as it comes, which is the claim you have is that the charge was not reasonable, right? I think that what the motion to dismiss points out is this was what they gave you was a preliminary estimate. You were never actually charged anything, right?
No, I was never charged. They do instead of fulfilling the request, they asked for me to return a different request that's altered that would be styled to a monthly request for which they would charge. A daily request is not charged. And also an identical request that had been made, but for a much larger range going from January 24th, the plaintiff can testify that Jason Frazier made a request that was for almost 2 years, and they charged $13.22 for that record. So the difference in charge and fees and costs for what's being requested is discriminatory. It doesn't make sense on the surface. And again, for the daily log that's so de minimis, it's free. The governor doesn't charge, the IG doesn't charge, the AG doesn't charge. The only one who wants to redirect and turn it into a different open records request is the Secretary of State. They're the outlier.
All right. So one of your points here is that if I have this right, is that comparing this to someone else who submitted a comparable request, your difference of $16 makes it unreasonable.
It does, Your Honor.
So we're here about $16.
Not so much. It's the amount that they're wanting to charge for a monthly log that I did not request. Again, the production that I'm asking for is for a single day, and that is where the charge and the fee should not be there. If I did that across all the agencies, then collectively that does become an issue, Your Honor, it does.
All right. So on this particular claim, I think this, as I understand it, is one that I don't think has ripened. They gave you a preliminary estimate that you had some concerns about, and you think maybe, discriminatory. They charged someone else something different. It's unreasonable. But unless they actually sent you a bill and said, pay this, then there is no charge for me to assess if what's reasonable or not. I mean, they could have come back after the fact and said, here's what you actually have to pay. I understand that, you're saying the estimate was not good, but we never actually got to a charge. And the statute doesn't talk about estimates. It talks about what you were actually charged. And you concede you were actually never charged anything at this point in the process.
That is correct, Your Honor.
All right. Well, I'm going to say count 3 then is as a matter of law, not one we're going to get into today. So with that, I'll open up the floor. If there's anything else you think we need to address, I think we would dive into any evidence that you have. On behalf, let me just start with, about on behalf of the plaintiff, anything else that you feel we need to address before we would allow you to present the evidence you have?
There were other motions, but I believe we can wait on those till after we rule today. It may not be, till you rule today, it may not be necessary. There is a motion to leave and amend. There is
Well, on that, I mean, as a matter of right, you can amend your complaint. So your complaint is considered amended, just so you know.
Thank you, Your Honor. And then there was a motion for production of a conflict of interest, not asking the court to rule on that. Just if there is a waiver that exists out there, the plaintiff would like to have that. If there isn't one, that's fine. Just that's one of the items that was requested in that notice to produce as well. And also in the motion, in that conflict of interest motion as well. There is the preservation and the injunctive relief, but I believe that, like defense counsel said, most likely can be addressed by Your Honor once we adjudicate the proceedings today.
All right. Well, and just to let you know, because some of this involves some statutory analysis and everything, I'm probably not going to be issuing, today addressing each and every claim. I'll be following up with a written order so I can dive into it some more. Today is just to present all the evidence you have so I can rule as I need to. But anything I saw your response to the waiver issue, and I think your point is well taken there. That I don't think that's anything you can be compelled to produce in this situation. Do you have anything you want to add for the record as to whether one even exists?
Yeah, I would just state that our office doesn't believe we have a conflict, so we have not created a conflict waiver letter in this scenario. So we wouldn't, in any event, have anything to produce.
All right. Anything on behalf of the defense you think we need to take up before I open it up to the plaintiff for evidence?
There is the claim for attorney's fees and that's referenced in the motion to dismiss, but just figured
Okay.
to raise that.
And to that end, Mr. Meadows, I don't know if that's one you did respond to. No. But should there be any should we be getting into attorney's fees here when they say that as a matter of law, you don't have the right to them?
The act specifically mentions damages and cost. So that leaves that interpretation up to the court, I believe, and that could be including attorney fees. I included my prior case that did have attorney fees as well. And I know that the court sometimes will give equal value to a low-paid public defender. So I'll leave that to the discretion of the court. I want to reserve my right to be able to ask, and I believe they were properly pled in the original complaint and in the opposition that I had to.
Are you saying you have other damages and costs outside of what may have been paid to an attorney in the prior dismissed action?
All the costs that were associated with preparing the court cost, Your Honor, the court reporter, copying fees, parking fees for coming down here, the mileage on the way. And again, if there is any value that is assigned to the time of the plaintiff for preparing, but all of the fees I would say are out there and should be considered.
Do you have any, they've cited some authorities, saying that if you're not an attorney, you can't get attorney's fees. Do you have anything in response to that specific provision?
Well, that's what I alluded to with the damages and cost. And so those would be left to the court and the court's discretion if they grant something relative to that. Again, that's broad and fairly open when it says damages and cost. What were those and what did that tally to?
Okay, well, I'll say my initial reaction to this is that asking for costs and fees for another action, even if it's all kind of, you think, part of the same narrative, that prior action was dismissed. The claims you have in this complaint don't incorporate those or bring those in here. So I don't think that would be appropriate to shoehorn those in. But to costs and damages you have in this case, as he talks about parking and sharing the cost of this court reporter, would those still be fair game in the defense perspective? if he were to prevail on any claim.
We're very well aware of the types of things that are considered appropriate costs. And we, if the plaintiff's successful, I think we could do a bill of costs at the end of the case that, you know, we haven't been provided with any information
Right.
other than the court filing fee to know what these alleged costs are. But I'm certain that we could go through the usual process and have those items submitted to the court.
All right, so the motion will be granted in part on that point. Then there's a narrowing of what is appropriate and what the possible costs could be recovered, but that's not going to incorporate anything from the previous action. It's not going to incorporate attorney's bills or fees that he didn't incur in this specific case. So with that, then, I think we can turn to any evidence that you believe is appropriate. And in this situation, Mr. Meadows, when someone's representing themselves, because, you know, the other party has the right to cross-examination. This isn't something I think that we can proceed through proffering or you just kind of referring to certain documents. It has to be through a more formal process where you're sworn as a witness and you can give a narrative account, but before you would refer to a document or exhibit, you're going to have to authenticate it. You're going to have to follow the rules of evidence, and they're going to have the right to object and say if the rules of evidence haven't been followed and whether something's admissible or it's not. So to that end, I would say if you've got exhibits that they don't have a copy of, I might not have a copy of them printed, so I'd certainly appreciate a courtesy copy. But it's going to have to be a kind of an orderly narrative in that respect. All make sense?
I understand, Your
Okay.
Honor, and I have exhibit binders that I would offer for the judge so that we can go through each exhibit that I'll present today.
Okay, that'd be helpful.
May I
Of
approach?
course.
Thank you. I have an identical for the defense. There's nothing in here that has not been presented or filed with the court today.
All right, thank you. All right, then, Mr. Meadows, you can call your first witness.
Your Honor, could I start with an opening statement? Would that be appropriate?
Just in the interests of everyone's kind of time, if it's just kind of reiterating what's in your complaint, I've read it, and I think I'm familiar with the arguments and the things that you're contending. So if that's all you were hoping to cover, I'd say let's dive into it.
Yes, Your Honor. Your Honor, I would offer exhibit
So
A.
you're the first witness.
and off.
You're calling yourself is what I'm saying.
Okay, I thought I was presenting exhibits to the court at this point and not swearing myself in as a witness.
If they're self-authenticating, you can, sure.
That's what
All
I
right,
was
what have you got?
anticipating. Your Honor, I would offer exhibit A, and Your Honor, there also is sworn testimony that I've provided through affidavits and certifications with verifications. So those would serve some purpose, I hope, for today. But exhibit A,
Fine. We'll do it one at a time, perhaps, sir, but this is where things can get a little convoluted, and we'll see how this goes. So you are tendering Exhibit A.
Exhibit A, I offer, Your Honor, what Exhibit A establishes is plaintiff's written Georgia Records Act request dated September 23rd, 2025. It establishes a lawful open records request directed to the proper custodian expressly requesting personal inspection, narrow in scope, seeking verification of records received on September 2025. That is the trigger there, defendant's obligation under that act.
All right, this is how it's going to work. You just tender the exhibit. You've given us a copy. We know what you're talking about. You can just identify it by a sentence. You say this is self-authenticating. And so to that, is there any objection on behalf of the defense?
Our degree is self-authenticating, but we have no objection.
All right, then without objection, Exhibit A is admitted. What else?
I would offer Exhibit B, and that is defendant's portal electronic response. And that's defendant's response redirecting plaintiff to the portal access and electronic summaries And it does not address inspection, cite any statutory exemption, or conduct a record-by-record analysis.
Any objection to Exhibit B?
Same, as before, no objection.
All right, Exhibit B is admitted.
Your Honor, I would offer Exhibit G. Exhibit G establishes, and this is a live violation. It shows plaintiff made an in-person request, custody was admitted, inspection was refused, no exemption was cited. Plaintiff was told inspection was categorically unavailable. That's not a misunderstanding.
Any objection to Exhibit G?
Yes, this is an affidavit, that Mr. Meadows is free to testify about these things, but I think the affidavit summarizing it is not appropriate.
All right, Mr. Meadows, so this would be considered hearsay, even though it's sworn in an affidavit as admissible at a motions phase, but not in an actual evidentiary hearing. So the objection there would be sustained. What else?
Exhibit H is the blanket denial email.
All right,
Defendant states that records are not available for inspection at any Secretary of State office. That statement's categorical, policy-based, and not record-specific, cites no statutory exemption. Deal versus Coleman is the case law applicable.
any objection to H
We do not agree with the characterization of it, but have no objection.
as a document? Exhibit H is admitted.
Exhibit H3 is the open record spreadsheet log. H3 establishes that the defendant produced the log. It shows missing entries, selective logging, no ability to verify completeness.
All right, objection to H3 as a document.
Honestly, I can't read it. And I believe I have seen other copies of the same document that are legible. I don't know if the court can read it, but 54-year-old eyes cannot make any sense of that.
This is one that was, I mean, this was provided you by email, right? You've just printed a copy of
Yes,
what
Your
was sent
Honor,
to you by email.
it's H3, and if it's provided electronically, it may be clear for you to see it there.
Yeah, I mean, I can make it out. But there are parts of it that are cut off and such. So I think we would say that H3 is, if you can provide by USB the actual original file, I would deem that admitted. And this is a printed copy of that. It's say for demonstrative purposes, but just make sure that there's nothing else on it unless there's other electronic exhibits that we admit, and make sure opposing counsel gets a chance to look at that before you give it to the court reporter. But H3 would be, if it's the original electronic response, is that admitted without objection?
Certainly.
All right.
You think it's a true and correct copy of the response that.
All right, with those caveats, what's next?
Exhibit J, the comprehensive monthly log email. I offer that, Your Honor. That establishes daily logs do not exist. Monthly logs are comprehensive. Some open records requests are never logged, and inspection is unavailable.
Any objection to J? It's admitted.
Exhibit X3, the Secretary of State standard operating procedures that were provided by defendant on September 29th in response to the October 10 open records request, and as a result of the motion to produce, the X3 establishes that there were no inspection procedures for personal inspection. It institutionalizes selective logging, routes all requests away from inspection, and replaces statute with internal policy. Backed by Favorite versus City of Marietta.
Ms. Young?
I would object to the characterization of the document, but not to the admissibility.
All right, so X3 is admitted in its entirety.
Y2, Your Honor, and that is offered. Excuse me one second.
All right, because I suspect these might all be handled the same, Y2 and Y3 appear to be documents that were received and provided to you by Mr. Frazier.
That's correct, Your
All
Honor.
right, and he's talked about those by affidavit. Let me just check in with the defense. Is there going to be is there an objection to Y2 and
I
Y3?
believe so. No, I think Mr. Fraser is here and he could testify.
Sure.
And whether that's necessary, I think it depends on what the purpose for which this is being offered is. We might be able to stipulate some things. For example, if the purpose is to show that Mr. Fraser submitted his response, this request, and he was charged $13.22. I don't think we need to have it. But if we're going to get into matters of substance about the logs or things like that, then we probably will need to have it.
All right, as I take it, it's for the remaining issue is going to be that what he got was different than what Mr. Meadows got. And so it would be to the nature of the responses. And so to that end, it sounds like that's going to need to be established, explored through testimony. So at this point, I would say Y1 and Y2, same issue as before. Can't authenticate something just through an affidavit and an evidentiary hearing. So those would be, the objection would be sustained to hearsay on Y1, Y2. They may come in through other ways, but not right now. And Y3 is this?
Are
is
those
this something
logs,
that
Your
you
Honor?
received? All right, tell me about Y3.
Y3 of the logs provided that are pertinent to the case that show the comparative logs and what was missing and what was produced to the plaintiff and shows its incompleteness
So this is what was produced to you, Y3?
in electronic form, and that's its printed version.
Okay. All right, any objection to Y3?
I believe these logs were not used to either.
That's correct. I had asked for those, and only recently that was part of the October 10th request was for the defense to provide that, and also in the motion to produce. And we have what they're going to produce here today, and so that was offered in lieu for the court to be able to make a decision as to the completeness of the record.
Okay, so Y3 is what you got or what Mr. Frazier got?
That is what I obtained through Mr. Frazier through sworn affidavit.
Okay, so
Kind of falls within our general objection to, or our general view that Mr. Frazier would have to testify to authenticate this.
all right, so again, then to Y, understood. So again, at this point, the objection to just admitting Y3 is self-authenticated would be sustained. So that would also be, that would not be admitted right now. So that's Y1 through Y3. All right, what else? Anything else?
Your Honor, those were the exhibits that I'd intended to provide today.
Okay. What other evidence?
Your Honor, the standard operating procedures that were a part of X3, and I believe that will be just establishing that. So if X3 is offered, no inspection procedures. Did we rule on that already?
Yep, we went
did?
through them
I'm
all. That one's
sorry.
in.
I regress. I apologize.
That one's in. All right, what's
And
next?
those are the exhibits that I had to present today.
Okay. Any other
And
evidence?
that was, other than what has been pled and is already offered in the pleadings there, that was what I had available today to discuss were those exhibits to try to keep it streamlined for the court. There were several other exhibits, but they were offered as part of the overall package there for the court to understand, but had not intended to utilize those as part of the presentation today.
All right. Any testimony, anything else that you want to have as part of the record?
Well, at that point, I guess the swear in the plaintiff to be able to provide testimony. Would that be appropriate, Your Honor?
If that's what you'd like to do, this would be the time.
That's all I've got left to do, Your
Okay, then.
Honor. Excuse
All
me.
right. Then to that, if you could raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter before the court should be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. You can lower your hand. And as I mentioned, you can proceed in narrative fashion, though. But if you hear an objection, just pause so we can sort through that.
Mhm. The plaintiff,
First person's fine.
I made the lawful requirements to establish a lawful open records request and established, and excuse me, Your Honor, I just have to turn to my section next. That a lawful tailored open records request was made, that the public record was denied by the defendant, was requested. It was a categorical denial, and no statutory exemption was cited for the blanket exemption as to why there was no inspection provided. The plaintiff can also testify that the defendant's own standard operating procedures identify no logging opportunity, that there is selective logging, excuse me. It's acknowledged in the standard operating procedures that some of the requests are never logged. There's the reliance on summaries rather than the underlying records, and the complete absence of any procedure for personal inspection. The requirements that were needed to be able to establish a lawful open records request were made. That was a categorical denial of the ability to inspect, and that did take place and occurred on September the 30th, when plaintiff appeared before the Secretary of State's office and requested personal inspection, and that was denied. Plaintiff can testify that the October 10th open records request was never completely fulfilled. There was but one item that was supplied to that open records request, and that was the standard operating procedures. And so that request also was not fulfilled until 109 days later on September the 29th. The plaintiff can also, I testify that I did not submit a portal request as alleged by the defense in an October 29th email from defense counsel Dana Yu, where she indicated that I had completed, and I have a sworn statement before the court that I did not complete that, but the assertion is that I had made an open records request through the portal, and I did not. And the defense cited that they had responded to me on October the 16th, and that is false. I did not receive a response from the defense to that request on October the 16th. That was only supplied to me on January the 29th, 2026. And the only response to that production was the standard operating procedures. There's also an October 31st open records request that defendant did not respond to other than supplying one item as well. So the incomplete data that was supplied. I requested from the Secretary of State's office excuse me, I have to clarify my dates. On September 30th, where at my personal appearance, I requested for an oral open records request to identify the officer, the open records officer. I was denied that information. That was not provided to me, and I never got a response to that oral open records request. I can testify that the standard operating procedures does not provide an opportunity for an oral open records request. And I was initially denied even making the request, but once I made the request, it was never fulfilled. It requested email for that day, whatever email that the Secretary of State had received, they did not supply that. That was one open records request. And then another open records request was for the open records officer, and I was denied that. I can testify that on September the 22nd that I did make an open records request that was not included in the log that was provided to me. The log that was provided to me was provided in lieu of personal inspection, and that opportunity for personal inspection was never provided. And I was denied that right to personally inspect. I can testify that this has been an ongoing beginning in December of 2023, that this denial has occurred. I can testify that the Defense and Secretary of State at one time did supply daily open records requests without charge, and then they stopped without explanation. I can testify that the Attorney General, the Inspector General, and the Governor supply almost identically styled requests without fail when requested and without charge.
Object to that because there's no evidence.
What would be the basis of the objection?
I guess I can deal with that on cross.
All right. You can proceed, sir.
Your Honor, may I request a short recess? 5 minutes to be able to take a restroom break.
That's fine. All right, we'll be back in time, off the record.
Thank you.
Yeah, a whole bunch of them. Here we are. Yeah, it's so much, it's a nice. Oh, yeah, I think I mentioned, yes. It's been a little while. It's a thing that's like. Yeah, that's what's got to be done.
I was too good.
I'm sorry. Good morning. I mean, I'm a secret. Until after we're done. What chef was, I don't know. Yeah, we'll keep it secret. If you can't figure it out. Okay, well, from anybody.
The only people here are on our side.
Yeah, right. What's that about? It sounds like you. Yeah. Yeah. He's well. That's my father. It's my father.
It's way over there.
Yeah.
We'll see what you can. Across from this dude. I guess so. That's weird.
Poor Dutch, right? Very big deal.
And as far as that.
I couldn't get it to us. Well, two different reasons. I know, crazy. I mean, it's been a headache.
Should see me. What's that shirt? Is that it? I got locked up 2 times. Not this early.
Yeah.
Hold on, let me make sure. I was the one, I was 3. And they switched it around, but I represented myself.
Tough today.
I just joined them.
Oh, wow. That's what we thought, right? But that didn't just.
No, this is against you.
I mean, crazy.
Oh.
So, 6, 7, 8, maybe. Right.
You gotta use your phone, you gotta do it out that hallway. Not that hallway, that hallway.
All right. I thought it was all right until the judge came in. My phone.
Overcome all remain seated.
All right, we're back on the record. Mr. Meadows, you can resume.
Yes, I believe I've established the timeline that open records requests were lawfully made and that I was denied the opportunity to personally inspect and that is the harm that was received by me, that I was not able to give him that opportunity to inspect and verify the record as the statute provides. May I call a witness, Your Honor?
Well, if that concludes your personal testimony, now they get a chance to cross-examine.
Oh, yes, sir.
And then when you're all done, you can call another witness. So, Ms. Young, I turn it over to you.
Like to try to get through each claim in chronological order if I can. So your first request that we have an issue with is the third. And this is the personal inspection issue. Is that correct?
That is September 23rd personal inspection.
And isn't it true that in response to that, the Secretary's office did provide you with, by email, with the information that you sought, or at least with what they believe to be the information about the need for you to put down?
I can't testify to what they believe that they thought they gave me, but
On September 29th, I'm looking at paragraph 15 of your initial complaint. You say that they provided electronic copies of certain records via email. Is that correct?
that is correct. There were incomplete records provided on September 29th in lieu of the production as stated by the defendant. That wasn't
And
what the inspection was requested.
with a missing attachment, but then they sent a follow-up email with the missing attachment, correct?
That is correct. There were two emails. One was allegedly missing an email, but it was produced. That was from the Elias Law Firm, 12 pages, unredacted. An unredacted email, I believe, or open records request that had been provided in that correction.
And what was the problem you contend with what was provided to you on September 29th? Was it didn't contain your own open records request?
What I maintained was that the request was for inspection, and production is no substitute for inspection.
So you were going to show up at the Secretary's office anyway, even if they had given you every record you claimed to be entitled to?
If I felt that it was and had belief that it was incomplete, then my request was for
That wasn't my
inspection.
question. My question was there anything they could do to stop you from coming down there and demanding to see those in person?
Allow for inspection.
So the answer would be no. You wanted to show up at the secretary's office and see them, even if they had provided you those exact same documents by email.
There was no belief that there was my record exempted. That's perhaps correct, but it's hypothetical.
Was there anything that you alleged to have been missing from that production other than your own open records request itself?
Can you restate?
My understanding of your previous testimony was that what they provided you on September 29th was incomplete because it didn't have your own open records request on it. Is that right?
That's correct.
So let's say they get this request from you, they print the log before they have logged your request in. That makes it an incomplete record?
That's correct.
Where in the Open Records Act does it say that agencies have to have a pristine and itemized log of every open records request that they receive?
In the responses to me, it was referred to as a comprehensive log.
That was not my question. Does the Open Records Act require agencies to maintain a pristine and completely accurate log of every Open Records Act request that they receive?
Yes,
Isn't it actually true that the agency's obligation is to produce the records it has?
that's what what I had asked for were the actual open records request
You actually asked for a
that were,
log, isn't
that were,
correct?
that were made, all
You asked
made.
for a log, they gave you a log. You don't like the log, but the Open Records Act does not give you the right to documents you like. It gives you the right to documents that exist. Is that correct?
Disagreed that you're, if I may correct, the September 23rd did not ask for production of a log. It asked for inspection.
Do you have what exhibit? Is that Exhibit A?
That's Exhibit A.
Now, you already have your own open records request, correct?
The one that I made, yes.
And you have the response to it, correct? So that has been produced to you.
There
You
was,
also
there
have a
was
log of everybody else's request,
a
correct?
response, but not inspection.
So is the issue inaccuracy or is the issue inspection?
The issue is inspection. The open records request specifically on September the 23rd asked for inspection. It was specifically crafted. Didn't ask for a log. It didn't ask for incomplete. It said all of the open records.
Actually, what it said is the following data and data fields, name of requester and description of requested records. Isn't that correct?
And that's part of the administrative notes, but paraphrasing
That's what
perhaps.
you asked for. Isn't that correct?
If that's in the record,
It's Exhibit A. You can take a
I'm
look
looking.
at that. These are your words.
I hereby request to personally inspect all open records requests submitted to the Georgia Secretary of State's office on September 22nd, 2025.
And then you go on to say, the request specifically includes, but is not limited to, the following data and data fields, name of requester, description of requested records. Isn't that true?
That's what if that's what's printed,
With
yes.
the exception of your own name and your own description of requested records, they gave you a document that had the names of the requesters and the description of requested records, correct?
There was a production provided of names and requesters and request,
Now,
excluding my open records request.
now you have made many requests like this, both from the Secretary's office and other agencies, correct?
Yes.
And do you dispute that sometimes within the description of requested records, there's sometimes going to be PII or other types of confidential information that have to be redacted. Do we have a dispute about that?
Redaction is part of the act and it's, yes, there is personal
You're not
information.
trying to look at somebody else's social security number, for example.
Oh, heaven
right?
forbid, no.
And you don't have a problem with the fact that the secretary, if they have information that has somebody's social security number or date of birth or something like that, will redact it before giving it to you.
I don't want responsibility for that. Please,
So we agree on
redact.
that. What is it that you were looking for the secretary to do in person that they had not already done for you by sending you this record?
View my own open records request to confirm and verify
The one that you
receipt.
sent.
All right, and just for the record, let's not, make sure everyone can finish their sentences. So if you have a response, Mr. Meadows, you can finish that.
Can you repeat the question? I'll lose train
Well,
there.
So I think what I just heard you say is you wanted to verify that they had received your request, but doesn't the fact that they responded verify that they had received the request?
That does not comply with my request. That was for inspection. Plaintiff had belief, I had belief that my record was not included. And that's supported by the standard operating procedures that say that some open records requests may not be logged. They just linger on an email. And if that's the case, I wanted to be able to verify.
Where in the Records Act does it say that they have to put your own request on a log when they are responding to your request?
It's a record. It is a record. It is a lawfully submitted open records request. If it was requested by me, then if it was requested, doesn't matter who the requester is. It asks for all open records requests submitted on September the 22nd. It excluded mine.
And they gave you, they believe to be the records of everyone else's, correct?
I don't know what they believe they provided me to
Do you
be.
have any reason to suggest that they didn't in fact give you data that you received every else?
Proved to be false later, is my belief. Is that they gave me a half a deck of cards. There was 16 open records requests that witness Jason Frazier is willing to testify to today.
And we know that they did in fact receive your request because they responded, correct? So there's no issue of them not actually having received your request. They responded to it. Therefore,
No issue about receiving. It's about production. I was requesting.
Let me clarify this, Mr. Meadows. You received 8. Mr. Frazier, you contend, will later say that he received 16. Of those 8 that you say are missing, how many of those are your own requests?
None.
All right. Ms. Young.
Is it your understanding that an agency, if they do not have a record, has to create one?
Agency should not create what does not exist. They should only produce what is in the record that is responsive. If I request for an open records request, all of them that was submitted, presumably my record would be a part of that.
So we agree that if you were hypothetically to ask for something that simply did not exist, then the agency does not violate the Open Records Act when they don't give you anything in response, correct?
That would be true, that oftentimes you'll see there are no records responsive to your request. That could be a possibility.
Is it your understanding that the Secretary's office already, before you ask for it, has a daily log of all open records requests?
Say that again, please.
Is it your understanding that the Secretary's office has a daily log of all open records requests before you ask for it?
I don't know what the Secretary of State has or does not have before or after I request at any point. That's why the styling is requesting anything that was made. Presumably, if it was a record submitted the moment that it was submitted and made, it became a record that would be responsive to any request that is asking for all open records requests made on that day.
Right, but you've accused them of lying when they say that they do not customarily produce daily logs except for when you ask for them. I'm just trying to figure out if you in that position right now.
Well, the response in Exhibit H3, that the log even identifies it as a daily log. The only way that you can have a monthly log presumably is with daily entries. The standard
They make these daily logs for you. They don't exist until you ask for them and they create them for you. So you're taking the position that they are lying when they say they do not have these records independently of your request?
Again, what I would state is that in order to have a monthly log, you can only have daily entries. And the daily entries are entered in as per the standard operating procedure. It says entered daily.
Okay.
So a log presumably exists according to the standard operating procedures. It's
About how many times have you asked the Secretary's office to create a daily log for you?
I've not asked for them to create anything that didn't exist. I've asked for them to produce a log or summary in the event it does not exist. I don't know what may or may not exist. And in the event it doesn't exist, then I want to see the actual open records requests themselves. That's how that's styled.
Let's talk a little bit about when you did show up at the Secretary's office. You were asking about an open records officer, correct?
And a custodian, use the word custodian.
Well, a custodian, and use of legal terms, has a different definition in the Open Records Act than an open records officer. Is it your testimony that you asked about an open records officer?
And yes, an open records officer and a custodian,
And
both.
your belief is that the provisions that allow an agency to designate an open records officer is so that they can provide you with a point person?
I'm sorry, can you rephrase that? I was distracted.
I wrote down during your, during the discussion that, not during your testimony itself, but during the argument on the motion to dismiss, that you believe that the purpose of that provision is to give you a point person or someone responsible so that you can be in contact with them to basically negotiate over your request. Is that a fair statement?
That's reasonable.
Where does it say that in the Open Records Act?
It does not.
In fact, isn't it true that what it says about an open records officer is that if they designate one, then the 3 days doesn't start to run until you submit the request to that person? Isn't that?
I don't understand what you're saying.
So you acknowledge that the Open Records Act doesn't say anything about providing a point person. Is that correct? That's something.
It doesn't refer to a point person
That's
at all.
something you would
It
like, but that's not.
it does
something
not
that you can find in the act, right?
does not refer to a point person. It refers to a custodian and it refers to an open records officer. If there's one that has been designated, as we've learned today, there is one that apparently has been designated or de jure in some form or fashion, but presumably on the day that I requested, there was an open records officer.
And they gave you the name of Joy when you asked who that was, correct?
That is correct. They gave me that was it, Joy.
I want to turn to the issue of costs. You have in the past made a lot of requests to the Secretary's office, correct?
To find a lot.
You think more than 10?
Yes.
More than 20?
Yes.
More than 100?
Yes.
More than 200?
Over what period of time?
Ever?
Yes,
More than 1,000?
no,
Okay, so somewhere between 200 and would you say more than 500?
I believe at last count 402, excluding since this took place here since 2024 forward would be. And that's the nature of my daily open records request. I mean, that is essentially prima facie evidence that if I'm doing a daily open records request, there are 365 days in a year. They don't take place every single day.
And how much have you paid to the Secretary of State in terms of the costs or fees for producing information in response to these 402 requests?
My de minimis request typically result in no charge until they attempted to decline my open records request and offered an alternative fee structure.
So if an agency, as a courtesy, decides not to charge you for something that they could have charged you for, does that obligate them to continue to do so for all the hundreds of requests that you're going to make in the future?
The criteria is established by the act. And if the request requires less than 15 minutes of work, it doesn't matter what a courtesy or.
Evidence that your requests take less than 15 minutes of work.
Well, I can testify that the Attorney General doesn't require them that long. The governor doesn't take them, any other state agency. In fact, the only outlier is.
All right,
the
let's pause
Secretary
there.
of State.
Ms. Young.
Record of these requests and no proof that there is any, that these are apples to apples comparisons.
All right. Well, in terms of the evidence, I mean, I guess you could establish that there was testimony if he has the basis for doing so, and you can explore that through cross. So, Mr. Meadows, if you remember the question, you can answer it, and if he's able to link that up, I'll give it the consideration is due. Go ahead.
What evidence do you have that it takes the Secretary's office, not any other office, but the Secretary's office, less than 15 minutes to respond to each of your 402 requests?
Their responses to me in December of 2023, they did not charge me for those requests.
So because they have extended you the courtesy, perhaps, of not charging you for a request that may have taken more than 15 minutes, you think that's evidence that it did not in fact take more than 15 minutes?
You use the word may several times there. I don't know what may be. What may be.
What
Yeah.
do you have that it took more than 15 minutes?
I-
Or less than 15 minutes?
By evidence that I was not charged.
So that's
You
your-
did, is the agency undercharging?
Do you have any other evidence that a $30 charge would be unreasonable for the requests that you?
Yes, the testimony that can be provided by Jason Frazier and a comparative log that extended far further. I asked for 1 day and was being provided an alternative charge there. If the Secretary of State takes 2 hours, 5 hours to fulfill a daily log, a monthly log, or a yearly log, then it is what it is and they charge accordingly. But what will be provided in testimony will be $13.22 to come up with an almost 2-year log. And I'm asking for 1 day. I don't know what it costs the Secretary of State. It's presumed that it's less than 15 minutes because I wasn't charged.
So you're presuming-
Well, let me pause there. I think I'd mentioned at the outset that the issue of the reasonable charge was no longer a viable claim since he got an estimate, not a charge, and I think that was conceded by plaintiffs. So I don't think that's really relevant for the evidence today.
Give me 1 second to confer with counsel. Oh, can you explain to me, so we've talked about the personal inspection request. What is it that you contend is the later request for, in front of me, October 1st.
I believe that's October 10th, Counselor.
This is the one that, we had some issues with it being transmitted to the wrong email address. Now, the email address that you have been using is what? It's openrecordsc@gmail.com.
Correct.
And the secretary's email address is openrecords@sos.ga.gov, correct?
I believe so.
And so somehow your response to that request, instead of getting transmitted to openrecordsc@gmail, got sent to openrecords@sos.gov. Our office provided you with that information belatedly, but we did provide it to you, correct?
I believe it was 109 days late on January the 29th, 2026. There was a one document provided out of probably 40 or 50 items that were requested that were related to this case.
And we showed you that there had been an attempt at an earlier transmittal through what appears to have been a clerical error with two very similar email addresses that did not go to yours, that actually went to the secretary's office. But you did get the that transmittal document showing that they had made that error, correct?
With an accusation that I had submitted a portal request, which later I corrected in the record that I had never made a portal request. So there was a production, there was a response and an accusation. False.
But we did provide you that information showing that there had been an effort that due to a clerical error was not transmitted to you, correct?
And perhaps we can call witness Dana Yu to explain that before the court here.
I think that documents speak for themselves. You do stipulate that you received those emails, correct?
The emails, you're talking about the response on,
Ms. Yu's email to you and forwarding the earlier email that was sent to the incorrect email address, correct?
that was created by the Secretary of State and forwarded to themselves to create their own record. Eventually, I received on January the 29th, a response, partial response to that October 10 open records request.
Both your email and the secretary's email are nearly identical except for the ending, correct?
No, I disagree. They're not nearly identical. They are substantially different by about, I don't know, maybe 11,
Start with
10
open
or
records, right?
10. That's true.
Isn't
They
it
they end differently though, with a different tag, different .com completely. One has .ga.state.gov and the other one says .gmail.
Isn't it possible that someone could inadvertently, without intending?
All right, Mr. Jones, you're gonna have to step out.
Isn't it conceivable that in typing open records, somebody either through an auto population or by muscle memory might have typed sos.ga.gov instead of email at the end of the open records email?
That's possible, but considering pending litigation, you would assume that the attorney would be more accurate with their production of that, or whoever was doing that, considering the importance of that. Again, it's believed that that was an entry done for their own internal tracking that was sent deliberately to them that would later be forwarded out. I don't believe that that was an error at all.
Do you have any evidence that this was an instance of willful bad faith as opposed to a clerical error?
I have no idea what caused it.
And also, your lawsuit wasn't served until November, correct?
Sheriff Fulton County perfected services, I believe, November the 20th, if I'm not mistaken.
So and this was in October that this clerical error would have happened.
That is correct.
So there's no reason to think that that person typing it was aware of any pending litigation at the time.
Unless they're here to testify to that, I don't know. I
I'm asking
would,
if you have any evidence that anybody at the Secretary's office would have been aware. You were the one that said that they would have been more careful because they knew of pending litigation. Do you have any evidence of that?
believe that was identified in the email, but I'm looking to the specific line for that. Yes, in line D, related to civil action number 25CV013635, page. I'm looking at the October 10 open records request page, well, for me, page 3, but it becomes,
Sorry.
says,
Actually, didn't introduce that as an exhibit, but I suppose
it was included as part of the exhibits that were in the X series that were provided as part of your September 29th production. That open records request was part of your submission to me and was repeated in that response.
I'm a little confused, but
Well,
what relief are you seeking for it at this point?
I am seeking enforcement of my personal inspection rights, designation of a responsible open records official.
What's
A
the second one?
revi- Can I continue to answer?
Yeah, you can finish your answer, Mr. Meadows, but I mean, we could get to things that we actually need as a matter of evidence. I mean, I don't want to just recite things that are already part of the record. So with that, all right, she's going to rephrase the question. We'll go from there.
So your right to personal inspection, what kind of order are you asking the clerk to enter? Are you asking the clerk to enter something that relates to the September 22nd request, or are you asking the court to order something with regard to future?
And to continue with what I would request, and I'll go into detail to first. Defendant, this is what I would request. Defendant would permit plaintiff to personally inspect responsive open records request in related public records identified in plaintiff's request, including but not limited to open records request received on September 22nd, 2025. Also, that inspection shall be provided within a reasonable time period during business hours, mutually agreed upon location, and would be supervised access to the electronic systems.
So what you want is to go to the secretary's office and look at the documents that you've already been provided with, plus your own open records request somewhere in their office in person. So they can just print the same document out and hand it to you across the desk, and that would satisfy their obligation. As long as it had your request on the log in addition to the other requests on the log.
What you, again, you identify as a production of a copy. My request is to look at the terminal to actually see my open records request and to see it in the others, to see them. I'm looking to see it in the electronic record, which is the mechanism provided by the Georgia General Assembly for verification. If all records were exempt, everybody would make every record electronic and they just simply issue the exemption, and the Open Records Act becomes Nothing. It's just no.
Where does the Open Records Act say?
All right, Ms. Young, for purposes across, I think getting into legal argument, it's not helpful. So let's just get to the point of what facts on cross do you think you need to establish?
What is it that you're asking the court to do about an open records officer?
Designation, a responsible open records official. The defendant would identify and designate an open records officer or custodian responsible for coordinating compliance with with any orders or with the inspection. The designated individual would serve as the point person of contact for purposes of inspection, scheduling, verification, and most importantly, resolution of compliance issues. And can I continue with the rest of what I would request? If you've asked that, Your Honor, I'll stop.
You've got it in your complaint. I don't need you to just read to me. All right. What else?
Complete the record.
All right. Anything else on your behalf, Mr. Meadows, in terms of your own personal testimony?
I did. Unfortunately, that eludes me now, so I'll go on to call the witness if that's appropriate.
All right, you may call your next witness.
Your Honor, I would like to call Jason Frazier to the stand.
All right, Mr. Frazier, you can have a seat in the witness box.
Raise your right hand. Each well from the testimony about this case, you should give the truth and nothing to help you.
Yes.
You may be seated. While speaking clearly to the mic, state your name and speak.
Okay. My name is Jason Frazier, Jason, Frazier, Frazier.
Mr. Frazier, did you make a request to the Secretary of State, I believe, Open Records Request 709, requesting logs of all the open records requests submitted?
Yes.
And what was provided to you?
I was provided, an invoice, I guess first off for $13.22. And then I was given 5 different files electronically, an Excel file. I can read through those if you need me to. But a CSV file, which is titled ORR log 2025 redacted. Another file titled ORR 2025 CONTD X, and that's an Excel file. I guess to shorten it a little bit, it looks like the document 250814_043009 redacted. ORR log 2024 redacted, and I'm not sure why this one was in there, but ORR log 2025 398 onward redacted.
Those open records requests, did you review and scan, look over those?
Yes.
Did you see my name, the plaintiff's name, Brant Meadows, anywhere in those logs?
No.
Those logs started from January 2024 and went until September approximately, on or about the 29th of 2025. That's the length of those logs?
That's correct.
And nowhere in those logs did you ever see my name ever presented as a requester?
I did not see your name there.
And would you read from me from what you requested in your, my point is to see if you requested all. I believe you did,
Yes.
but I wanted to
Yeah,
hear for the record.
It's a short description. Exactly what I requested was I would like a list of all ORRs submitted between 2024 and today. And then I go on to say, please include request number and description. I am simply looking for an easy download that takes less than 15 minutes. If that time frame needs to be reduced to accomplish that, feel free. If you can add more with the click of a button, please add more. Excel format or CSV is preferred. Essentially, all I was looking for was the documentation. I didn't want to create an onerous request. I didn't want to spend a lot of money on this, so if they could give me more, I would absolutely like to have more. But if they needed to go to a shorter time frame because I was more looking for 2025 documents, or I could break it up if that was necessary. That was what I was going for.
And Mr. Frazier, but before that open records request, had you ever met the plaintiff before or talked to him?
Not that I believe.
And so that request was independent and was done of your own volition.
Absolutely.
Understand. Do you have anything else you would like to add?
I think that pretty well sums it up. I would like to reiterate that, yes, I did this on my own accord. I was looking for a specific open record. I wasn't sure when it occurred. And then I had heard that Mr. Meadows was also doing open records. So just on a whim, I sent it to him. And I guess that was where some things got interesting.
Mr. Frazier, for the specific date of September the 22nd in those logs, can you testify to the accuracy that there were 16 open records requests made on September the 22nd in your logs?
I don't have that in front of me. I can grab my computer and verify that, but I apologize that I didn't bring that up.
If I supply with you a log of those, could you verify that?
Yes.
Your Honor, may I provide a log?
You can approach the witness.
Oh, there we go. Sorry for the trouble and the delay there.
Excuse me, Your Honor. This says that I'm muted on this screen. Do I?
If you could just click stay muted.
Okay.
Have you had a chance to review that?
Yes.
Does that appear to be accurate, Mr. Frazier?
I guess I can't say whether or not it's accurate, but this is what I received.
Mm-hmm. Your Honor, may I submit one more piece of evidence that we've admitted in, which were those logs that he had provided?
Is that what he's holding?
He had the file. He can, I just wanted to have him testify to the authenticity of what he had received and that the logs that I had printed out for the court today were indicative of what he had received.
Is that marked as an exhibit?
Yes, sir.
Which exhibit is that?
I believe that's Y3.
Has he taken a look at that?
That's why I wanted to supply to him, if you don't mind.
All right. Was your witness?
Mr. Frazier, that is the 2025 CONT printout. Does that appear to be accurate to your recollection?
This is definitely the format and layout of what I received. Without reading through every word of it, I can't say 100%, but I have no reason to doubt the authenticity of this.
Thank you. I have no further questions.
All right. Any objection to Y3? All right. Submitted.
Fraser, we met earlier.
Yes.
Just a couple quick questions. You were charged, I believe, $13.22 for this production, correct?
Yes, it was a 2-year log of the open records that were given to the secretary, or that came from the Secretary of State's office.
And you originally asked that it would be provided for free, but when you were told that it would have a charge associated with it, you paid that, correct?
Yeah, I sat on it for a few days and wasn't sure if I wanted to continue ponying up more funds in this ongoing situation, we'll say. But I did finally pay that $13.22.
Okay. And the date of your request was, I believe, October 7th. Is that correct?
I believe I submitted it on September the 23rd, actually.
Oh, I'm
That's
sorry.
what
I
it shows
believe
on the
the
board.
response was October 7th. Is that?
Well, I paid on, the invoice was on October the 1st. It could have been the 7th that I had received that. It's within that time frame.
Do you know whether your printout of the log was generated before, the same day, or after Mr. Meadows' version of the log?
What was the date of his log?
I'm not sure exactly, but is the answer you're not sure either?
I worked independent of Mr. Meadows. I know what I requested, and I think you know what I requested.
Okay. But as we sit here today, you're not here to testify that your log was printed on the exact same day as Mr. Meadows, are you?
You'd have to give me the exhibit for me to compare.
And then you mentioned during the direct that you were provided with various logs that were redacted. What's your understanding of why those logs were redacted?
If there's a social security number or PII, then as Mr. Meadows testified, I don't want to see that either.
Okay. And were there instances within your log where some of that information did appear and had to be redacted?
If it was redacted, then I didn't see it to know that what was there before.
Were there places in your log where you could tell that some information had been redacted?
Yes, but I wouldn't have thought that actual requests in entirety would have been redacted.
All right.
A person's name and log number should not ever be redacted.
But you agree that social security numbers, dates of birth, things like that should be, and in some instances were, in your case, redacted.
Yes,
correct?
according to the Open Sunshine Law in the state of Georgia, those were and should be redacted.
Okay. No further questions. Thank you.
Let me confirm, Mr. Frazier, do you recall what date you received the response to your request?
I know the invoice was October 1st. I apologize. I don't have the date that I received it, but it was shortly after October 1st. It would have been very early October.
So you received a communication indicating it's done, here's the invoice as of October 1st?
Yes.
All right. Anything further, Mr. Meadows?
The log that I provided of the summary of September 22nd, can it be entered into the court as evidence, Your Honor?
Do you have that marked as an exhibit?
That was previously Exhibit Y2, I believe. Yes, that was the comparative analysis pack. It also had an additional summary in there as well, Your Honor. It's mostly duplicative, just the one that Mr. Frazier has, just verifying that.
All right. So are you, for Y2, are you asking Mr. Frazier questions about Y2?
I just wanted to make sure it was admitted in his evidence with the court.
Ms. Young, thoughts or position on Y2? All right. I mean, it's got more commentary on it than anything. I would say it's inserted as a demonstrative. Mr. Meadows, this is something you prepared,
Yes,
comparing
Your Honor.
exhibits. And so for demonstrative purposes, I would say Y2 is admitted. And we can go from there. Is there anything further for Mr. Frazier, though?
No,
All right,
Your
sir,
Honor.
you can step down. Anything further on behalf of the plaintiff?
Your Honor, I have two, but one particular request. And again, the plaintiff's counsel could testify to the inaccuracies. I believe that's a matter of the record before the court that was not contended. So in lieu of requesting defense counsel Miss Yu to testify, if they'll accept that correction that I clarified for them was indeed accurate, and the X series of exhibits are reflective, and that there's no objections to the X series X1 through X7 that unfortunately mischaracterized me as having done something that I did not. And I just want to make sure there are no objections to that. Ms. Yu is the one who can speak to that. And so I'm mindful of the court and procedure, and I really don't want to create any problems. If you're willing to concede that point, then I'll move on.
I don't believe we objected to X3, and we think that it can, the document can speak for itself and that the court can interpret that document however.
All right, so as I understand your request here, Mr. Meadows, we've got your response that you received admitted as X3. We've got Mr. Frazier's now admitted. We've got your demonstrative showing the differences between the two. I don't quite understand what you're saying, Miss, you would be questioned about or add to that. Setting aside the whole issue of it's very much a very strong presumption you don't call opposing counsel. It's just not what happens unless necessary. And so what is it that she's adding to this equation that you haven't
I
already?
believe they've adequately satisfied that. In their failure to respond to my correction, I'm going to let speak for itself. And I can move on to the next witness, Your Honor, and let that drop.
Okay, then you can call your next witness.
Your Honor, I'm here as plaintiff and named as defendant as Secretary of State Brad Raffensperger. There was a hearing notice provided. Is Secretary of State Raffensperger available for testimony or to be a witness today?
Yeah, that's not really how it works. Mr.
And
Meadows.
that's fine. I leave that alone there. Can I call Terry Sweeney?
I will state that we do plan to call Ms. Hill as representative secretary.
Okay, and all right, and sorry, who did you say, Miss
Terry would like to call Terry Sweeney to the stand.
Sweeney? Okay, Mr. Sweeney can come forward.
You swear affirm the testimony out of this case you should give. Proof to help you.
Yes, I did.
I'll speak clearly to the mic. State your name.
Thank you. Terry Sweeney. TERRY-SWEENEY. I live in Johns Creek, Georgia.
Mr. Sweeney, were you present on September 30th when plaintiff went to the Secretary of State's office to inspect records?
Yes, I was.
Did you hear the Robert Center or Mr. Spearman, either of them? And can you acknowledge that you were there for that conversation?
Yes, I was.
Did plaintiff request for the custodian and the open records officer?
Yes.
Was the plaintiff denied that opportunity to have the open records officer identified other than the name Joy?
Yes, and so was I.
Mm-hmm. Is there anything else that you can add?
When we went there, the intern was sitting down at his desk and we were asking him a couple of questions about who he needed to talk to about open records. He said he wasn't exactly sure he was allowed to answer any questions because there was a lawsuit pending. Oh, I'm sorry.
No, you can let Mr. Meadows. Do you have any response to that?
So,
Well,
I believe it's important to this case for determination of the facts.
well, the importance exception to the hearsay rule isn't one I'm familiar with. So unless you got something more specific, I'd have to sustain that. So you can rephrase the question.
Mr. Sweeney, did you hear the plaintiff, Mr. Meadows, request an open records request regarding an email, the last received to Secretary of State Brad Raffensperger?
Yes, that's right.
Did you hear the Mr. Spearman or Mr. Center attempt to deny the opportunity? Did Mr. Center deny?
Yes.
And
Again, hearsay is out of court statements.
I understand that. Can you testify to what the plaintiff requested?
It was denied.
I have no further questions.
All right, any cross? Okay, you can step down, sir.
Thank you.
Any further witnesses?
No, Your Honor.
All right, any evidence on behalf of the defense?
Yes.
Your Honor, before we do that, I'd like to make a motion for directed verdict. Specifically on the grounds that, plaintiff has testified. He basically wants this court to order the Secretary's office to designate an open records officer. If the court does not believe that the Secretary has already done so, the law does not require that. And if you look at 1872B1B, that is a defensive statute that benefits the agency. There's not an ability for a plaintiff to come in and say, you have to designate an open records officer so that I can have a point person that I can talk to about my request.
And I appreciate that distinction. It's just been muddled somewhat because the analysis depends on what the agency's done. And first, it seems like he may have been, the evidence that's been produced is that he's told there is one that exists. There's one in previous filings that says there is one, and now you're telling me today there isn't one. So it'd be pretty easy to know, again, was anything ever put into the legal organ of Fulton County saying, here is the open records officer? That would be the prerequisite. I don't know.
To our knowledge, I don't believe there's any judicial authority that has interpreted whether or not you can designate an individual without naming a person or not. So that's why I think we may have kind of added to the court's confusion a little bit because we're not quite sure how to argue it in the absence of any authority on this issue. I think we can stipulate that to the extent that the law requires naming an individual, that has not taken place. If the court believes that the law permits the Secretary's office to designate just open records officer as a title, I think then they have done that and then there's no violation.
To have an official open records officer, again, I know I keep coming back to this, but it seems to me it'd be a very easy thing that's a thumbs up, thumbs down, which is if you've elected to designate someone, something, or a title, you then have to notify the legal organ of the county. You pay for an ad in the Fulton Daily Report. And if that never happened, then it would appear that this paragraph was never satisfied, meaning the Secretary of State never had an open records officer.
And I think our response to that would be that even if there had never been an effective designation, what that means for an agency is they cannot say to a requester, well, our 3 days did not begin to run until you sent the request to the right person. That doesn't create a cause of action for a requester to come in and say, well, you failed to designate one altogether or properly designate one, and that creates some kind of breach for which we have a remedy.
But it could create a breach if you had designated one and then didn't identify it like you were supposed to. So it's like this threshold question of whether you have one or not is one I've got to figure out because it's part of the complaint. And so again, your position today is you do not have one and you've never had one. Is that accurate? I mean, I don't know how else I can work through all this.
I think that we can take the position that we've never had one.
Okay.
Because I believe that they did have, at least at some point in the past, have had one.
Okay, but at the time frame at issue here, September 2025, the position of counsel and judicial admission is that there was no designated open records officer compliant with the statute.
And that none is required.
And I recognize that, but I just need, so I know how to actually look through this thing.
There definitely, are people that, serve in that capacity and, but in terms of designated official, I think that for the purposes of this case on that date, I think we'd be willing to stipulate that there was not a designated open records officer. And for that purpose, the claim must be dismissed because there is no requirement that they designate one.
All right. Mr. Meadows, any response to that?
I believe that goes to policy and discretion of the court, Your Honor. I don't see harm that's been caused, and so I would ask for you to deny the request of defense counsel.
Well, the request is saying that because they're admitting they didn't have one on the date, that the claim essentially of yours evaporates as a matter of law because they're not required to, which is what you said at the outset, which is the statute is permissive in this regard. And there was a lot of confusion. Sounds like some of it's self-inflicted on whether they actually had one, but they're coming here and saying they didn't. And as a result, I don't see what remedy or claim you have unless you can direct me to one.
Again, this is where I'll have to rely on the courts and being a pro se, asking for the lenience of the court to be able to interpret exactly what the request is of the defense. I believe it goes to some of the foundations, though.
All right. To the extent that may be relevant to other issues at play here, like the good faith or substantial compliance or other things, that's part of the record. But as to it being an independent claim without a designated open records officer, some of the alleged violations that have been claimed in the complaint, I think, again, become there aren't grounds as a matter of law. So I think the directed verdict would be appropriate in that case. All right. Anything else?
Yeah, so there was a pending motion about spoliation of records that I think we haven't heard any testimony about spoliation, and we would ask that be dismissed as well to the extent that that is part of what the plaintiff is asking for. In addition to that, when we look at the prayer for relief, to the extent that this is directed at any future requests that he may make, I would remind the court that obey the law injunctions for future behavior are not permissible. It's really unclear to us what specific relief is being sought with regard to any actual outstanding requests. You have, a case of 2 different logs generated 2 different days, but those are the records that were available and produced. The Georgia Open Records Act does not, it's not an information finding statute. It is a records production statute. If a daily log or a monthly log changes because you have added or subtracted things from a log over time, the secretary's obligation when it prints that log and produces it is complete. This is not a records accuracy statute as much as this plaintiff would like for it to be. So the only evidence that we have is you produced document A on day 1 and document B on day 2.
Right.
These 2 documents are different.
And let's be precise on the dates. We know Mr. Frazier's was October 1st and his was received
October 7th versus the 29th or 20
he said October.
were produced.
Okay.
Um,
We'll break that down for me.
So you have, I believe the request was made on September 22nd, I believe, but the production for Mr. Meadows was made on the 29th and then he showed up on the 30th.
Right. So if Mr. Meadows gets a response on the 29th.
Mr. Frazier's was on October 7th. Stands to reason that some additional items might have been logged in between those 2 dates. But that does not prove that does not prove that on September 29th, they didn't produce the correct record to Mr. Meadows. There's no proof of that there. They produced the log as it existed on that date. If things were added or subtracted at a later time, that's not a violation of the act. The act does not require, these are workflow logs. These are not meant to be some kind of chain of custody or meticulous tracking of anything. That nothing in the law requires.
But
that.
this is an important point, though. I mean, Mr. Frazier said that his log was on October 1st. So why do you
Requested it on the 1st and then it was produced on the 7th, I believe.
I mean, I specifically followed up. Now you can tell me if you think the evidence contradicts that through the documents or something, but I specifically asked him when he got that request or when he
Well,
says he received a response on 10/1.
but they were not on the same date. He submitted it.
Your Honor,
25th.
may I?
Sure.
Invoiced on the 1st.
Invoiced on the 1st, which
October
suggests the work was
1st.
done, I thought.
Shows the upload.
Right. So there's basically, what, 2 days separating the respective productions, right?
Point is, you have two different requests
Sure.
on different days, and you got two different documents.
I mean, but you're asking as a matter of law, right? And so if 2 days separate them, couldn't it also be a factual inference here that, again, the standard is negligence? I'm not saying that the requests were intentionally removed, but that two different responses were given to the same request for information.
I think that what we'd like to remind the court is that the obligation is to produce a record if it exists, at the time of the request.
Right. And so why should I infer as a matter of law that on the 29th,
Remember, it's the plaintiff's burden of proof to show something more than that.
and they've showed that 2 days later, they had 16 requests that the Secretary of State was aware of for that exact date. And so in those 2 days, I'm supposed to, well, just let me finish the point. In those 2 days, I'm supposed to infer that, when you're gathering everything that came in the door for the 22nd, that those extra 2 days produced the extra 8 responses?
Well, I think it's certainly not appropriate to infer that they didn't. And there's been no testimony
Yeah.
as to that point.
But just that circumstance alone is something that a fact finder could use
Well, he was
to infer
asking
the other way.
He was asking for a daily log.
Right.
Mr. Frazier asked for something different, at a different time. The fact that you have two different sets of records doesn't mean that that first record didn't satisfy the obligations under the act. So they produced the document that was requested by Mr. Meadows on that day. They produced a different document to Mr. Frazier on a different day. The Open Records Act just requires you produce the record that you have, not the record that they want, not the record that they wish you had.
Well, I mean, I think your position was that you generated this document from scratch regardless, right? But you're generating it based on other records that are, look, I mean, regardless, I think that this isn't going to be as a matter of law. So I would deny the motion on that point.
All right. Thank you, Your Honor.
All right, unless there's anything else to argue, then defense, if you have any evidence you wanted to present.
Yes, Your Honor. Would you prefer an opening statement? It's very brief, but we can go right into the.
Let's not, just in the interest of time, let's
Okay.
just jump into it and you can
Yes.
wrap it all up when we're done with the evidence.
Sure. So the Secretary of State would call Ms. Yoshana Hill to the stand.
Hi, good afternoon. My name is Yoshana Hill, Yoshana, last name Hill, Hill.
Thank you, Ms. Hill. Where do you currently work?
I currently serve as the elections attorney with the Office of the Secretary of State.
And is that your job title?
Yes,
Okay. And how long have you been employed by the Secretary of State's office?
I joined the agency July 1st of 2025.
Okay, great. And what are your general job duties?
Sure. So I provide election support to the election division through legal review, as well as supporting our staff members regarding open records. So I'm one of the individuals who does redact the open records log. So I provide legal support to the elections division.
Great, thank you. And are you familiar with Mr. Meadows' request to your office?
Yes, I am.
Right, and how are you familiar exactly?
Yes,
You've
so
worked-
part of the open records process with the Secretary of State's office is once the record request is received, I'm part of the team that looks over the records request to first determine whether we are the custodian of the record. Do we have these records? So I'm part of that team to think through that process, specifically for the elections division. After thinking through whether we are the custodian of the record, if we can produce the record and the record has to be redacted, as the attorney, I'm one of the individuals who will redact the record.
Great. And so suffice to say, you're familiar with the kinds of open records requests that your office receives?
Yes, I am.
And you're familiar with the way that your office receives and logs those requests?
Yes, I am.
And also with the way that your office responds to them?
Yes.
Okay, great. So I want to ask you some questions first about how your office receives those open records requests. By what transmission methods does your office accept open records requests?
Yes, so we receive open records requests through various transmission methods, from mailed requests, emailed requests, as well as we have a portal called Just FOIA, which is a software platform for managing open records requests.
Mhm. And how does it help your office manage those open records requests?
It streamlined the process. So we used to have an Excel spreadsheet in which we will log every single open records request, or most of them if they need to be logged. And that particular Excel spreadsheet captured all of the requests. But now that we transition to using a software platform, it streamlines the request so that we're better able to fulfill the requests.
Great, thank you. And just to clarify, Just FOIA is an exclusively online program, correct?
Yes, it is online.
Okay, great. And so you alluded to the fact that your office has not always used Just FOIA. When did your office begin using Just FOIA?
Sure. So on or around June 2025, we migrated to using Just FOIA. So previous to that, as I mentioned, we had a single Excel spreadsheet. So during June of 2025, that's when we did our onboarding for our staff members. We introduced them to this new platform. We provided some training. We met with the vendor. So the Just FOIA platform was rolled out to the public September 22nd. So that's when we posted a link onto our website, and the public could directly enter their request into the Just FOIA platform through the link that we provided online.
Great. And what kinds of open records requests does your office receive?
We receive a lot of different open records requests, some where we are the custodian of records, some where we are not. For example, for those that we're not the custodian, we may receive requests regarding arrests, requests regarding medical records, pet adoptions, a lot of different things that are not within our purview. So as the Secretary of State's office, we deal with corporations, elections, securities, charities, cemeteries, those things. But we do receive a lot of requests where we are not the custodian of record.
And what kind of information do those requests sometimes contain?
They sometimes contain personal identifying information, including but not limited to partial and full Social Security numbers, full and partial dates of birth. Individuals may actually upload their medical records or a copy of their driver's license or a copy of their Social Security card. So there are a lot of PII within the actual request. So sometimes requesters will have their full name, full date of birth, and a full Social Security number, which is why redaction is very important.
Great. Thank you. Now I want to turn to how your office keeps track of those open records requests through Just FOIA. So when your office receives a request through Just FOIA, what happens?
So when we receive a request through Just FOIA, we get an email notification letting us know that someone has requested some documentation. After we receive the request, then and it's automatically logged. So it's all online, is automatically logged. Then we have a staff member who starts to process the request. The processing looks a little bit different depending on the type of request. For example, if we're not the custodian of record, we may not necessarily log that request in because we're not the custodian. So we may respond to that individual, letting them know that we're not the custodian. If it's something that we can answer quickly, we also don't, we may not log that as well. But for those requests in which we cannot answer quickly and we may be the custodian of record, we have an internal conversation around how can we reproduce this? and whether an exemption is in place for redaction, either part or whole, or whether the document has to be produced.
And so how are requests dated in Just FOIA?
It's automatic. It's
automatic.
automatic. So, except for weekends and legal holidays, it's dated the next business day. After 5 p.m. it's also dated the next business day,
Mhm.
but the date and timestamp will be automatic.
Okay, great. And how are completed requests treated in Just FOIA? Is that something separate from a request that immediately comes in?
Yes, so once requests are completed and either the document is produced or we communicate with the requester that we can't produce the document, there's an internal workflow within Just FOIA, within the platform. And so that completed ORR then goes to a completed log, which is a separate log from our active in progress open records requests.
Okay, great. And just to backtrack slightly, but how does your office keep track of open records requests that it receives outside of Just FOIA? So by mail or email?
Sure. So by mail, we date stamp it and we scan it and we manually enter it into Just FOIA. If the request is received via email, then we will also enter it into Just FOIA. So we want to have all of our open records requests in one place, which is the Just FOIA platform.
Great. Okay, great. Now, I'd like to turn to how your office generates and then produces logs in response to open records requests.
Okay.
Well, how does your office generate logs in response to open records requests?
Sure. So creating a log is actually not part of the ordinary course of our business.
Mhm.
Whenever we get the request regarding an open records log, that's a custom report. That's something that we have to create. Because we are using technology and we are using the software platform, there's just no need at this current time to have an old school Excel spreadsheet log. So when we do get these requests for an open records log, we have to go and create it, which does take a lot of time away from processing other open records requests. And so when we create the log, I kind of want to walk us through a little bit of what that process is like currently. So what the process is like is that we have a dashboard on Just FOIA that shows the active, the in progress open records requests. So we have to export that log into an Excel spreadsheet or CSV, I think it's called as well. But we have to toggle on and off the parameters. So usually requesters will want the following data fields. So name, request number, date of the request, and description of the request. And the first part is to export that. We have to then, after exporting it, put it on a fresh Excel spreadsheet, do some formatting to it to make sure that it actually looks presentable for the requester. And then the most time-consuming part of it is that I will have to go through every single row and redact if there is a redaction that needs to happen. And so that's really where the timing comes in.
Mm-hmm. And so suffice to say, it's not easy to then create a customized daily list of open records requests that your office receives.
Correct. Not for a daily open records request. As an agency, on average, we receive 20 to 30 open records requests every single day. So to create a daily log on top of our existing workflow is laborious at best.
Mm-hmm. And so, if I may have one moment, Your Honor. So I suppose, just to put a fine point on it, how easy or difficult is it to generate a log, to create a log?
So it is easy to create a log. It is time consuming to create a log because it's not just about pulling an Excel spreadsheet.
Right.
There's more to it than that. We have to redact. We can't just give it to a requester if they're requesting it because there is so much confidential information in the actual record, in the actual log.
Great. Moment. So I'd like to now turn to Mr. Meadows' specific records request at issue in this case. Are you familiar with Mr. Meadows' September 18th open records request?
Yes, I did review that. Yes.
Okay. What records was he seeking?
I believe he was seeking a daily log. I cannot recall which day he wanted, but I believe it was a daily log of open records requests.
And that's not something that your office maintains?
No, it's not.
Right. And then moving on to his September 22nd, 2025 request. Are you familiar with that one?
I am now because of the lawsuit, but we did not, we don't have a copy of that particular request.
Your office does not have a record of having received it.
Correct.
Okay. And you may not know this, and that's fine. Do you know what day of the week September 21st was?
A Sunday, because I remember we rolled out Just FOIA
Mm.
on September 22nd, which was a Monday. So that's when we released the information to the public.
All right. And moving on to Mr. Meadows' September 23rd request and the circumstances surrounding it. Are you familiar with that?
Yes.
What did Mr. Meadows request?
I believe in that particular request, he wanted to conduct an in-person inspection of our open records log for requests received on September 22nd.
Mhm. And what was your office's initial response?
Our response is that our office is not open for personal inspection of open records logs. And I believe we did provide Mr. Meadows with a copy of, or we provided him with a copy of the September 23rd open records log.
Mhm.
So please forgive me in my pauses. There are a lot of moving pieces
That's right.
in this.
And this September 22nd, I believe the date was September 22nd, and I think that's reflected in the exhibits. This September 22nd log, how is it generated, if to your knowledge?
Sure. Once again, September 22nd is when we rolled out Just FOIA. And so this part is very important to kind of clear the record. September 22nd is when we rolled out Just FOIA to the public. So using our existing knowledge base at that time, we exported the log based on the active open records request, because that is what we knew at the time. So Mr. Meadows actually received the active, so the in progress open records request from that particular date. So that's how we pulled it. To give further information, as we were processing Mr. Frazier's open records request, which was a little bit different, but essentially he was asking for a log as well. We met with our vendor and we asked for clarification. How do we produce these reports? How do we produce these logs? And we show the vendor how we did it for Mr. Meadows' case. And then we got additional instruction from the vendor on September 26th. That's when we met with the vendor to give us another way to pull, download, export an open records log. And what the vendor showed us was how to export the completed open records for a particular date.
Mhm.
So that kind of explains the discrepancy between what Mr. Meadows received, which was just the active open records request for that particular date, and then what Mr. Frazier received, which was both the active, if we're talking specifically about September 22nd, which was the active and completed
Mhm.
open records requests.
And to be clear, those are two different documents, correct?
Those are two different documents. So we did confirm with the vendor whether we can just pull everything together so that we can give requesters just one Excel spreadsheet that contain both in progress as well as completed. Based on our conversation, there's not a way to do that, which is why Mr. Frazier received two Excel spreadsheets, an active and a completed one.
Okay, great. And so going back to the September 23rd request and the circumstances surrounding it, what did Mr. Meadows do after your office responded to him with the customized daily log?
Could you be more specific?
Was he satisfied with that response?
I don't think so. We're here today.
Did he, after receiving that, then appear at the Secretary of State's office?
Yes, he appeared at the Secretary of State's office on or about September 30th, at the Capitol office.
Okay, great. And I think you've already covered the why your office responded somewhat differently to Mr. Frazier. I should also ask, does your office maintain like a read terminal in the office?
No, we do not.
Okay. Now moving on to Mr. Meadows' October 10th open records request. Are you familiar with that open records request?
Yes,
Okay. How did he submit his request?
I believe via email.
Okay. Not through just FOIA?
I don't believe so.
Okay. And how did your office respond?
So we responded to his request. He requested several things in that October 10th request. So we responded partially that there were no responsive records for some of the things that he was asking for. We also responded with a redacted copy of our internal standard operating procedure regarding open records. And I think a portion of his request was regarding information that we deemed to be attorney-client privilege. And so we communicated that with him.
Mhm.
I believe that we responded via email.
Okay,
I
great.
think so.
And to your knowledge, to which email, where did your office send its response via email?
I don't have that document in front of me.
All right. I believe that testimony's already come out, Your Honor, so I'll move on. Are you aware of the email that Mr. Meadows usually uses when he submits open records requests?
Yes, I am.
And what is that?
openrecordsc@gmail.com.
And is that similar to the open records email that your office uses?
Yes, so we use openrecords@sos.ga.gov.
Okay. And to your knowledge, did Mr. Meadows ever reach out to follow up regarding this records request?
Which
The
one?
October 10th records request?
Not that I can recall.
Okay. And do you know if Mr. Meadows has now received that response?
Has not received the October 10th response?
Yeah, has now received it.
Has now received it?
Yes.
Yes.
Okay. And apologize to backtrack slightly. What date did your office send that initial email response to him?
I don't have the information in front of me,
Okay.
so I do apologize.
No worries. Well, Your Honor, I believe this is reproduced in one of plaintiff's exhibits that he has already presented, which is the email that was sent from the Secretary of State's office. I have a copy here in a different format, but it has essentially the same information. Would it be possible for me to provide this as a way to refresh the witness's recollection?
And did you say this has already been admitted?
It's essentially a reproduction of one of plaintiff's exhibits, the exact letter of which I can't recall
Is that the
currently.
electronic one where it's showing?
Correct, the just FOIA scan and then the Secretary of State's response.
So I think that was H3, if anyone wants to double check, just so we're clear.
Sure. Well, I will just, I believe, I'll just admit my copy to evidence. So, give me one moment, please.
So is this going to be defense 1 or defense A?
Defense 1.
All right. I mean, just if you could just show Mr. Meadows a copy, any objection to defense 1?
Sure. Let me just make sure that it's entire. Defense in its entirety.
I have no objection.
All right, defense one's admitted.
So Your Honor, may I approach?
You may.
Um, So Your Honor, so Ms. Hill, I've handed you what has been previously marked as Defendant's Exhibit 1. Do you recognize this document, those documents?
Yes, I do.
What are they?
So they are our response to the open record 2025-827. So I also have this attachment as well.
Okay, great. And is that the email and then also the subsequent page for the Just FOIA entry that your office utilizes for
Yes,
open
it is.
records requests?
Yes.
And does it accurately reflect the exchange between your office and Mr. Meadows?
Yes, it does.
Okay, great. And so what date did your office respond to Mr. Meadows' October 10th request?
October 16th.
Okay, great. All right. And again, did Mr. Meadows ever respond?
No,
Okay. Or rather, did Mr. Meadows ever follow up? I believe you've already. Yeah.
no, he did not. Not on this particular one.
Okay. Now moving finally on to Mr. Meadows' October 31st records request. Are you familiar with that one?
Yes.
And how did your office respond?
Once
Oh,
again, there were a
right.
lot of different asks within that one request. So I guess I'll start with the easiest one. The document that we did produce was around our open records policy. We produced that to him. There were, I believe, non-responsive records for a part of his request. So we responded that we don't have any responsive records. And then for a portion of the request, we did not know exactly what he wanted. And so we communicated that in our response, that part of his request was overly broad, or we did not know what exactly he was asking. So he received 3 different parts in the response to him.
And to your knowledge, did Mr. Meadows ever respond to your office's response to give clarification?
Not to my knowledge.
Okay. And just so we're aware of we can iron out the timeline here, when did your office initially respond
To which?
to Mr. Meadows' October 31st request?
I believe it was December 4th, 2025. I believe.
Give me one moment. All right. So this would be 2. Okay. Sorry, I have another set of emails.
I'm unable to determine who this was sent to here. Who is this right here? Who is on the the send to?
It should be.
I never received. That's why I'm asking you that question. It's another one of those erroneous sins that that defense has done. I object to that response, but I'd like to have a copy of it.
All right. Well, I'd like to admit these additional email exchanges into evidence. I can certainly go through the colloquy. And so
If you anticipate him objecting to them, I think you need to authenticate them.
sorry?
If you anticipate him objecting to them, I think you need to authenticate them.
All right. So
Do
if
you
I
have
may
these marked?
Yes, it is marked. May I approach?
You may.
You recognize those documents?
Yes, I do.
And what are they?
These documents include the original emailed open records request from October 31st, as well as our responses, plural. We first responded on November 5th, 2025, asking for additional time in order to process the request.
Sorry,
And-
I'll just stop you really quickly just
Oh,
to
sorry.
ask you how you recognize those documents. And
Yes, so I recognize this document as a person who is reviewing the open records request.
okay, great. And does it accurately reflect the exchange between your office and Mr. Meadows?
Yes.
Okay, great. And so at this time, Your Honor, we'd move to admit what's been marked as Respondent Exhibit 2.
Meadows? Any objection?
Well, I object to the accuracy of who they had sent that to because I can't identify who it is on there. There's not an identifier.
All right, to that extent, I think that goes to its weight, which you can argue in closing or in cross or if you have more testimony, but that wouldn't affect its admissibility. So she's identified them as to what she believes they are. If you think there's something else, you can follow up through your own means.
All right.
So it'd be admitted over objection.
Okay. Let's see, I apologize, I'm looking at the wrong document. So when did your office initially respond to Mr. Meadows?
We initially responded on November 5th,
Mhm.
2025, seeking additional time to process the request.
And what date did your office give in that response?
December 4th, 2025 is the date that we stated that we will respond or provide a response.
And did your office respond on that date?
We did. We provided a final response regarding that open records request on December 4th, 2025.
And so kind of pulling back more generally, approximately how much time do you think your office has spent responding to requests by Mr. Meadows?
I will give a conservative estimate. I would say around 10 hours responding to these particular requests.
Okay. And if I may have a moment to consult with co-counsel. That'll be all the questions for this witness at this time.
All right, cross-examination.
Again, would you state your job title and duties, please?
Yes, I am Yashana Hill. I'm the elections attorney with the Office of Secretary of State. I provide legal support and analysis for the elections division, and I also provide support regarding reviewing and redacting open records requests.
You mentioned the elections division.
Yes,
So the Secretary of State uses the elections division attorney to respond, or am I confused here? I didn't make a request to the elections division, and so you're identifying that you're the elections division attorney, but you respond to non-election division request?
yes, I do. So I provide support to responding to open records requests.
What training do you have in open records request?
What training do I have in open records
Yes.
requests? So in my previous agency, I have responded regarding open records requests, and also I'm an attorney. So I read the statute.
Specifically, though, what training do you have with regards to open records
My
requests?
experience as an attorney.
What procedures and rules do you rely on in fulfilling open records request?
The procedures that we rely on is part of the standard operating procedures document that you received, as well as my previous testimony. Would you like me to state that again?
Please.
Sure. So when we receive an open records request, we receive it by one of three methods, either mail, email, or through the Just FOIA platform, which is something that we rolled out around September of 2025 externally, and then internally June of 2025. When we receive an open records request, the first thing that we have to do is determine whether we are the custodian of record. So if we're not the custodian of record, or if the request is something that's quick, maybe a website link, then we won't log the request. In the event that the request requires more time, then we will log it through just FOIA. Internally, we meet with different division heads, as we stated in the open records policy document that you were provided, to determine how we can provide this record to the public. So sometimes that means providing the record in whole, or sometimes it means some type of redaction, or we also determine whether the record falls within one of the statutory exemptions to production.
And again, you mentioned 3 methods. Clarify those 3 again.
Email, just FOIA, mail.
Are there any other methods that you accept open records for? Do you accept or have open records received or by oral method?
Sure, that's one of the statutory options, is to receive an oral open records request. I have not, in my experience, processed those.
So that would actually be 4 methods then, would be more correct, instead of 3 methods, there are actually
Yes.
4? And what, and then also, what procedures do you know that are in place for handling the inspection of an open records request? If someone asks for that, what procedures do you follow for that?
Could you rephrase your question?
What procedures do you follow for handling an open records request for inspection, for personal inspection? What procedures do you follow?
I don't have any personal knowledge regarding an in-person personal inspection of an open records request besides what occurred with you. So I can't speak to that, whether that happened previous to me joining the agency in July of 2025. I can't speak to that particular aspect of it.
So it's your testimony that no one other than myself has ever requested a personal inspection?
No, that is not my testimony. My testimony is that I don't have firsthand knowledge regarding anyone requesting an in-person inspection of a log that has to be created, that is only available in electronic format, and that has to be redacted. I don't have any personal knowledge of that, and so I cannot speak to that.
But if someone did request what you just mentioned there, wouldn't you be involved in that?
Your Honor, objection. I believe that's asking for a hypothetical.
Overruled. You can answer the question if you recall it.
Sure, can you please repeat your last question?
You stated that there was a procedure and that you would be involved in mostly fulfilling those. If what you described there, wouldn't you be actively involved in those? Your job title requires you to be involved, and so.
Sure. And so with an in-person inspection with this particular case that I can speak on, because of the nature of the confidential information provided in the log, we made a decision that it would not be in the public's interest to actually have an in-person inspection because of the confidential information in that log.
And you know of you stated there are no procedures that you're aware of for in doing an in-person inspection?
I don't have any personal knowledge of any written procedures regarding in-person personal inspection.
You stated that some requests may not be logged. Is that correct?
That is correct.
What happens to those?
So some of the requests, we are not the custodian of record for those particular requests. So within the discretion of our staff member who processes requests is not logged. Other requests are just very simple, and we have a website that they may go to. So sometimes we'll just refer them to the website instead of logging it into just FOIA. So it depends on the request.
What constitutes an open records request made or submitted?
I'm sure you've read the statute, so what the statute says.
And so if you receive an open records request, it's a record, but it may not be a record that you're responsive to, correct?
Yes, there are some records where we are not the custodian of that particular record.
Did Mr. Frazier ask for all or active open records request?
Yes, he asked for all the open records requests for the time period of 2024 until the time that he submitted his request. But as I testified to earlier, we were rolling out the new Just FOIA system. And so we pulled for you what we knew how to pull at the time of processing your request, which was the active. And so as we met with our vendor and determined more functionality regarding how to pull the logs, because we do not create these logs as part of our daily duties, as part of our monthly duties, these are custom logs. We found an additional way to pull more information. And so that's what we provided to Mr. Frazier. And if asked, we would have provided it to you as well.
So Mr. Meadows, the plaintiff, asked for either all, or did he ask for just the active open records request that had been received?
I believe the request was for open records requested on a particular date. And as I testified to earlier, we used our what we knew how to do it at that particular time because it is a new system and we don't create these custom reports.
Understand the new system there, but all is all, and active is a different meaning. Can you describe to me the difference between what all is to you? If you receive an open records request that is made to the governor, but it was made to you, was that an open records request that you received?
Could you repeat the question?
If you receive any open records request, is that an open records request that you have received or that was submitted?
I would say yes.
If I write a check for a open records request and I owe money, who do I write that check to?
I don't deal with the processing of the fees for the open records request, so I don't have any personal knowledge as to who to write the check to.
You're familiar with the standard operating procedures, though?
I'm familiar with the standard operating procedures, but just to be clear on my particular role within the process, I review the open records request as well as make any redactions to it. As far as the payment of it, usually the payment is done online, but I do not have personal knowledge as to what happens when an individual writes a check. So I cannot testify to that.
So what is the process for an oral open records request?
I imagine, once again, I have not dealt with an oral open records request, but I imagine that the individual will make the request by stating what they want, the type of document that they want, and that has to be recorded by a member of our staff. But once again, I'm not familiar with that personally, so I can't speak to an oral
Are you
open records
familiar
request.
with any open records requests that have been made that are oral?
Yours.
Okay, and can you describe to me which oral open records requests that I made?
Yes, so from my understanding, I was not at the Capitol when you showed up. My understanding is that you asked a staff member, I don't know who the staff member is, who the open records officer is. So that's my understanding.
And what was your role in fulfillment of that open records request?
I learned for the first time about this oral request in your particular lawsuit. So I have no role in the fulfillment of that request.
And what is the process for personal inspection of open records as described in the Georgia Open Records Act? What is the internal process that you follow for handling an open or a personal inspection open records request?
I don't have any personal knowledge regarding in-person inspection of an open records request. So you'll have to refer to our policy and procedures document, our SOP.
So what you've identified then, instead of 3 methods, there are actually 5 methods of open records: email, regular mail, portal, oral, or in person?
That is not what I testified to. What I have dealt with is mail, email, portal, and I believe oral requests.
But
But
there are
not
no,
in, I don't have any knowledge of that, sir.
but there are no processes involved that you know of in internal processes for handling an oral or a personal inspection. Is that correct?
Your Honor, I believe he's already asked this question.
I think we've covered this ground, Mr. Meadows. So let's move on.
How do you know that I received the October 10, 2025 open records request response as you testified to earlier?
How do I know? Could you repeat your question, please?
How do you know that I received the open records request response to the October 10, 2025 request that I made?
We sent a response. I cannot speak to whether you have it or received it.
So some open records request can just be lingering on an email out there, never logged. Is that correct?
No, that is not correct. So as I mentioned previously, if we quickly respond to the open records request via email, we will email the requester back and provide them with the response. For other emailed open records requests, they are logged in just FOIA. We want to keep everything in a comprehensive place.
So at the time when I was making open records request, what was that procedure?
Could you clarify the time
Well,
period?
when I was making the September 23rd, 2025 open records request, what was the procedure for handling that?
Sure.
Were some logged, not logged, some in email?
They were logged in just FOIA.
How many open records requests have you received to date? Do you know?
Could you be more specific regarding the time
From
period?
January 1 till?
I don't have that data.
They're sequentially numbered. You indicated that 20 to 30 are received, but how many annually do you receive? Because you indicated 20 to 30 per day, and I'm doing the rough math, and I'm trying to equate where we are with the total number of open records requests received. We have an idea of that from the logs from Mr. Frazier for what was received until 2025 from January 1. It certainly does not reflect 20 to 30 open records requests received each day. So I was trying to reconcile what that might be.
Sure, it's an approximate number, sometimes less, sometimes more. It's
Are
on
there-
average.
Are there days when you don't receive any open records request at all? Zero?
Yes.
So in responding to my open records request on September the 22nd that asked for the summaries or logs, or in the event that they don't exist, the actual open records request, and you responded that there were no records responsive, and how long did it take you to respond to that particular email? It's the same one you'd responded to, the same method you had repeatedly responded to. So how long does each of those take? Just one of those responses?
Could you clarify the time? There are a lot of
On
different parts.
September the 22nd, 2025, you made a response to me that was a very similar response. How long does it take for you to respond in just that standard canned fashion?
So was this in response to your September 18th request?
The one on September the 22nd or the one on the 18th is fine too. Just that individual, how long does it take you to physically respond to an open records request that you tell me that there are no responsive records and that you can reformulate the request into a monthly log? How long does that take you to respond?
It depends, sir. It depends on our workload. So just to be clear, we receive a lot of open records requests, so we may not respond as quickly as a requester will want. For the September 18th one, I believe you were asking for a daily log at that point, and we responded that because of, we did it in the past as a courtesy, that we were no longer able to produce a daily open records log because it is time consuming to do that. September 22nd request, as I mentioned, I don't believe we have a record of that particular request, so there is no response.
I direct your attention to the October 10 open records request. And the response, the sole response to that was a single document, which was the standard operating procedures. And so that was the only responsive document. So when Mr. Meadows asked for the log produced to Brant Meadows on or about September 29th,
That was part of, this is a question, that was part of your, which request?
you just asking, how did you respond to the request that said the log, Mr. Meadows, I requested the log produced to me on or about September the 29th, which is Exhibit H3. I'm looking to verify that document and to have you reproduce that document, and that document was not provided to me. And what grounds did you choose to not provide that?
So I'm having a little bit of issue keeping up with the jumping from record to record because there are a lot of records at issue in this particular case, or a lot of requests. Are you referring to your October 10th
Yes.
request?
Mhm.
So in your October 10th request, there were a lot of things that you requested. Part of the response was that we did not have responsive records because you were asking some technical details. Another part of the request, you were asking for confidential attorney-client privilege information, and so we shared that we could not provide that to you under attorney-client privilege. And then the last part of your request for October 10th was regarding the standard operating procedures, or just procedures regarding open records requests, which we did provide to you.
So again, the log that you produced on September the 29th, which of those exemptions, or what did you rely on to not provide that as a response to Mr. Meadows' October 10th request?
Could you point me where you requested?
Third time, the log produced to Brant Meadows on or about September the 29th, our Exhibit H3. You were requested to supply that. What I had already received, the office was requested to supply that. And I'm asking you, what did you rely on to not supply that to the plaintiff?
I don't believe that was in the October 10th from my recollection. Please show me.
Your Honor, we have this exhibit before us already. Can I?
I'm gonna hand it to her if you think there's some point.
Well,
you
I'm
to
going to
make.
need this to continue to ask, but let's produce and show this particular part here. May I approach?
Mhm.
Thank you. This part of the request right there. What did you rely on to not supply?
Which one?
The
This
one
one.
right there, the log produced. You chose not to respond to that one, and I'm asking you, what did you rely on to not produce that?
Okay, so I think we have a different interpretation of this particular request because you're pointing to 2 bullet points on the request, but before that, you asked for SQL queries, SQL queries, data strings, filter strings. That was part of it. These 2 bullet points were part of a larger ask, a larger request within the open records request. And so regarding the SQL queries and the filter strings, we do not have responsive records regarding that. So that's how we interpreted this particular open records.
I'm specifically looking at the bullet point there and the second one. What did you rely on to not supply me on October 10th, that portion that I asked about for the log that was provided to me on September the 29th? What did you rely on to not produce that document as a responsive document in your response that excluded that particular item?
I
Your
think it's
Honor, I believe that she's already answered this question to the best of her ability and knowledge.
If we could just You can clarify it and then we'll move on. So if you can answer the question.
Absolutely. The question is, the request was for all SQL database queries, search strings, command line arguments, filter criteria or parameters used by SOS IT staff or Open Records staff to generate the following Open Records Act log productions. And the 2 bullet points that Mr. Meadows is referring to is the log produced to Brant Meadows on September 29th, and the log produced to Jason Frazier. Once again, the bullet points are part of the larger request, which is around SQL queries and filter strings. We do not have responsive records regarding SQL database queries.
Your Honor, that the answer for me was, again, I phrased it 3 times. I don't know that I got an answer. We continue to go back. I'm going to move on from that so that for this date here, we can continue on. There was a request, the log produced to Jason Frazier on or about September 23rd, that other bullet point. Why did you not reply or respond or provide that log? I asked for the log. I didn't get that log either, for the record.
Was there a question? Was there a question?
There was. And why did you not supply that? The log produced, specifically it asked for the log produced to Jason Frazier. What did you rely on to not supply that information to the plaintiff, to Brant Meadows?
So this question was just asked, and I will answer again, that the bullet points are part of the larger request, which is around SQL databases and filter strings. We do not have responsive records regarding what you asked in section 1 of that request.
Was requested of you to supply any instructions, request, or policies to filter, redact, delete, conceal, suppressed specific open records request. There was no response to that either.
Your Honor, that's testimony on his behalf. He's not asking
Reading
Ms.
from
Hill a
the
question.
log, from the report.
All right, why don't you rephrase the question?
Was there any response that provided any instructions, requests, policies to filter, redact, delete, or conceal or suppress any specific open records or any open records requesters for any public log?
We have no responsive records.
There was a request also for the missing sequence numbers identified between the 2 conflicting logs. What did you rely on to not supply that?
So I think I need to go back to what I said earlier in my testimony. There were not missing sequence logs in the sense that anything was deleted. As I mentioned, you were provided with the active, the open records log, and Mr. Frazier, after meeting with our vendor and determining the full functionality of Just FOIA, was provided not only with what we gave to you, but also the completed, the closed open records requests. So you received the active based on our understanding of our platform at the time. And then Mr. Frazier received the exact same thing that you received, as well as the completed open records log.
In reference to the October 31st request for open records, what did you supply as the response to that request?
We provided, again, the standard operating procedures regarding open records requests. And I believe we also have to refresh my recollection of that particular one. I have it in front of me. So we provided the SOP regarding the policy for open records requests, Some records were withheld because of attorney-client privilege, and we communicated that to you. And then other parts of that request, it was broad and vague and difficult to interpret without further explanation from you, the requester, around what exactly you wanted.
And so again, the only responsive record that you supplied was one document. Is that correct?
We provide the responsive record that we did have. So we had one responsive record and we supplied it. Just because a requester requests additional things doesn't mean that we always have a responsive record. So we provide the one responsive record that we did have.
Did you have the American Oversight Settlement? The plaintiff had requested the American Oversight Settlement. Was that not available?
Based on the wording of your request, we determined that you were asking for something that was within attorney-client privilege.
And how does that qualify for attorney-client privilege, the settlement to the American Oversight?
Based on our interpretation of your request, it was more than just the settlement to that particular case. It was also including information regarding our internal conversations regarding that case. So we deemed it attorney-client privilege.
So when the plaintiff asked for the email platforms that are in use, there was no response to that?
Where did you ask for that? Is that still with
Email platforms, versions, hosting, Office 365, Google Workspace, whatever you have. We just wanted to know what the system architecture was. That was part of the phrasing of that open records request. And
Sorry, could you point to that in the October 31st request so I can see it for myself? Or just let me,
Your Honor, may I approach again?
Yeah.
Right here. Side over here. That one.
okay, I can do that. Yes, thank you. Is this a larger version of?
Continuation.
Okay, I want to find it in this
Oh,
version.
you
That's
got it.
for
Okay.
just making sure we have the same thing, making sure I'm tracking. So I'm having a little difficulty locating what exactly you're referencing in my version of the record. So please provide me with a moment. Is this the exact request that our office received, or is this prepared for trial?
That was the exact one that was sent, so.
Can we
They
get
have
an
their-
exhibit number? Because I don't really have any idea what you're referring to. It's not in the binder.
Vince offered that up, and I
believe it's
believe we
Exhibit 2.
accepted the production
I mean, I
that
never
you
got a
just
copy.
provided shortly ago, but maybe I'm incorrect. Your Honor, it's not an exhibit before us today that I've seen.
I mean, I think she's saying she admitted it as defense exhibit
Yes.
2.
If I may approach.
All right, Mr. Meadows, what's next?
I was just waiting on my response there. Can you describe to me from the standard operating procedures how you count days, the 3-day rule? How do you count the day? And to remind you, I'll read from the standard operating procedure. If a request is received after 5 p.m. or on the weekend or on the state holiday, day 0 is the day that the open records staff member first sees the request during business hours. Does that comply with the Open Records Act?
I believe our operating procedures does comply with the Open Records Act. And just as a caveat, as I mentioned, we transitioned to a new platform. So that procedure document may need to be updated. So to answer your question directly, I believe the procedures document states exactly how we count days. And I believe that the day the request is received is considered day 0. And then we count from there unless it's a weekend or a holiday. Those days do not count.
And how does that request relate to the part of the standard operating procedure that says about a staff member first seeing the request?
As I mentioned, that's outdated because we use Just FOIA. Everything is automated.
You're saying that the standard operating procedures, is there a new updated version of the standard operating procedures?
There is not currently, but that is what we had at the time of your
So the-
request. And just to remind everyone, we rolled out Just FOIA around this time of these initial requests. So our procedures will need to be updated.
So this document here is what you're saying, to paraphrase, is outdated?
That is not what I said. We need to update it.
Very well. It
And
need- it
if I
needs-
can
it
please
needs
clarify
it needs
for the court.
updating.
Sure. If I can please clarify for the court, everything in that document is not outdated, but that particular provision regarding an open records officer logging in, that no longer applies because we've transitioned to using technology for that. So our Just FOIA platform.
But the portion of the standard operating procedures that you're referring to that's not out of date then is the part that says that it is not necessary to log requests for which a responsive material can be provided on the same day. That's still accurate?
It is.
Okay. And so, again, if an open records request is received, it may or may not be logged.
It may or may not be logged depending on how quickly we can respond to it. Sometimes requesters ask things that we can quickly respond to, and sometimes requesters ask for things where we are not the custodian of record. So there's no need to put that into our log for requests to be processed.
Your Honor, I have no further questions.
All right, can this witness step down?
Just a couple more questions quickly. Ms. Hill, does the Secretary of State's office make a good faith effort to respond to all open records requests?
We do, including ones where we have to create custom records.
And is openness and transparency a priority for the Secretary of State's office?
Absolutely, it is.
All right. No further questions, Your Honor.
Ms. Meadows, any recross on that point?
Can you restate that again?
The
response-
Secretary of State's office is committed to being open and transparent regarding our operations with open records requests.
And so relative to all submitted, responding to that, is any open records request submitted to to the Secretary of State, is that a open records request received?
It may be received, but as I mentioned, receiving an open records request is not the same thing as logging and processing it.
I understand that, but when a requester asks for all submitted, what do you interpret that to mean? All
believe-
records requests submitted, what does that mean, what you would respond to?
I believe I answered this a few questions ago. And so as I mentioned, it can be all of the open records requests that our office has in progress. So that can be one interpretation of it.
So when requester Frazier asked for all submitted, when requester Meadows asked it for all made, that indicates to you that that may exclude some records. Is that correct?
No, that is not correct. Like I'm repeating myself. We rolled out a new platform. We exported the data log for your open records request from our existing understanding because we do not have a monthly log in the ordinary course of our business. That's just not a report that we pull. So using the new platform, we pull the report, we pull the log based on our existing knowledge base. So we supplied you with what we had with the information that we had at that particular time. As we learned more about the functionality of Just FOIA, we were able to pull additional information, export additional data. So that's why there's a difference between what you received and what Mr. Frazier received.
And describe to me what a monthly log is.
No,
Your Honor-
Mr. Meadows, this is beyond the scope of recross, so if you've got any other specific questions
No, sir, Your
relating
Honor.
to transparency? Yes, it's coming up. All right, you can sit down, Ms. Hill.
Thank
Was there any
you.
other evidence expected on behalf of the defense? All right, we're going to take 5. We'll come back for any final argument.
I'll be right back. So this way? Thanks.
So what? This was the courthouse years and years ago. I'm from, I can't remember the name. Something about that, yeah. Yeah. Oh, my Coleman. And this is subdivision of Brant. So. I've been coming for 35 years. Yes. But it was turning I was. Right, you need to sort of sit there. Right, the lake is 10 feet low. We're trying to get something together with a couple of senators. We need to get the Tennessee River water down to Lake Lanier. Remember something we do? We had a program ready to go, pumping stations and everything 20 years ago. You can't. He said, no, we can't do it. Is what you should have done, but you could have done. You still have it? What are you saying? Good direction. The order was. But what we want to do is we want to make Tennessee help us get the water so we can pay them. Pennies on the dollar. Florida pays us and then Alabama pays us. Pennies on the dollar. They have a nuclear plant or something in Alabama that needs cold water. rail lines. We're thinking around a 6 foot. Like maybe. Or more. That is one of the babies.
Right, I can hear. Right.
All right, you ready? All right, we're back on the record. All parties and counsel are present. And so I believe at this time, the evidence is closed. And so to that end, we've been at it for a while here, and I think I'm pretty familiar with the arguments of each side. And so I'll just give everyone a few minutes here to wrap up any closing thoughts, clarifications they have. And we'll go from there. So I'll just cap it at 10 minutes per side and see if there's any follow-up merited. So with that, Mr. Meadows, anything that you want to highlight by way of closing?
Yes, Your Honor. I'm just sorting through many documents. My apologies, if you can just bear with me a moment. Your Honor, this case is not about form, technology, or convenience. It's about whether a state agency may replace the Georgia Open Records Act with internal policy and whether the statutory right of personal inspection still means what the General Assembly says it means. The record before the court establishes that this case has merit. All elements of an Open Records Act violation are met. The plaintiff has satisfied every element required to bring sustain this action. The evidence shows a lawful and narrowly tailored open records request for public records unquestionably within the custody of the defendant, a categorical denial of personal inspection, and no statutory exemption cited either at the time of denial or in litigation. This is all the act requires to shift burden. Once an inspection was denied, the burden moved to the defendant to justify that denial under a specific statutory exemption applied record by record. That did not happen. This case is therefore properly before the court within the court's jurisdiction and ripe for enforcement. The defendant did not meet its burden. The defendant did not identify a lawful exemption, conduct a record-by-record analysis, demonstrate harm, offer a less alternative consistent with the statute. Instead, the defendant relied on internal workflow, electronic format, portal availability, and a blanket policy that inspection is unavailable. None of those are exemptions under the Act. Inspection is not discretionary. It is the statute's verification mechanism. The standard operating procedures confirm the violation. The defendant's own standard operating procedures confirm selective logging of open records requests. Acknowledgement that some records requests are never logged, reliance on summaries rather than underlying records, and the complete absence of any procedure for personal inspection. This absence is not harmless. It explains the denial in this case. An agency may not eliminate a statutory right by omitting it from its procedures. This case has always been about verification. A spreadsheet is not a log. A summary is not an inspection. When an agency admits that some requests are never logged, inspection of the underlying records is the only way to verify completeness. This is why the legislature guaranteed inspection as a separate and mandatory right. Had inspection been permitted when requested, this dispute could have been resolved in days, not months, and this court would not be here today. This is not a frivolous or opportunistic case, The plaintiff has submitted thousands of open records requests to state agencies, including the Attorney General, Inspector General, and Governor's Office, without litigation. Those offices routinely resolved identically styled requests administratively, often through direct communication with the open records officer or custodian. This case arose only because the defendant refused to reconcile the record and adopted a blanket policy inconsistent with the Act. The merit of this case is demonstrated by the defendant's own productions, late filings, and internal procedures. Narrow, forward-looking, and relief is appropriate. The plaintiff is not asking the court to manage an agency. The plaintiff respectfully asks the court to enforce the statute ordering a personal inspection of records requested, requiring production of outstanding responsive records, including those tied to the October 10 request, directing prospective compliance with the Open Records Act, requiring the defendant's standard operating procedures be brought into compliance with the law, including inspection, designating a specific individual to coordinate inspection and reconciliation so this matter can be resolved administratively going forward, retaining jurisdiction as appropriate, preserving the plaintiff's rights to costs, fees, and other relief the court deems just should future noncompliance occur. Absent correction of the standard operating procedures and inspection process, the same issue will recur and the parties will be back before this court. The open record does not ask whether inspection is convenient, does not ask whether a portal exists, it does not ask what an agency prefers. It only asks one question: has the agency met its burden to justify denial under the law? Here the answer is no. For those reasons, the plaintiff respectfully requests that the court enforce the Georgia Open Records Act, grant the requested relief, and ensure that transparency functions as the legislature intended. Thank you, Your Honor.
All right, and just so I can, in bullet form, make sure I'm keeping track of all the different claimed violations of the Act, the responses and the universe we're dealing with here, we've got your response submitted September 23rd, which is documented in Exhibit A. And that's the one where you asked for personal inspection of all the open records requests on September 22nd. And then you've also, are you saying that the September 18th request is also one that was
Yes, Your
properly submitted and violated?
Yes, Your Honor.
All right. And then those October ones as well,
Your Honor.
October 10th and October 31st?
Yes, Your Honor.
All right, thank you. Vince?
I will try to keep it brief and not repeat things that have already been addressed, but there are a few things that I wanted to point out. In terms of what kind of order this court should write, it's really not clear to us exactly what further production is required right now, but I would ask that the court exercise caution in terms of any kind of order about personal inspection. We talked already about the provision that discusses confidential information and why we have to take safeguards over that, but we did not talk about subsection F of 71. Because I'm not sure that I understood until Mr. Meadows was testifying that, you know, what he really wanted to do, even for things that we know are not confidential, like his own open records requests, he wants, for reasons I'm not sure I understand, to look at them on the screen at Secretary's office. But F does not say that. It says when you're talking about using electronic record keeping systems like just FOIA, this does not give the members of the public the right to come in and, you know, have them pull up these screens and you know, play with the system or watch them, watch state bureaucrats, you know, doing the work of making these systems operate. It says that the choices are you produce either an electronic copy or, if the requester prefers, a printout. And I think the legislature, you know, was, you know, careful to say, you know, you get, when you're dealing with these electronic data systems, requesters get an electric copy or a printout. They do not say you can come and access our systems, you know, and see whatever you want to see anytime you want. So we would ask that you keep that in mind in terms of, to the extent your order talks about any right of physical inspection. You know, it does sound like there were a couple of issues, you know, the main one being, why did the Fraser log have more than the Meadows log? The testimony of Ms. Hill explained that. To the extent that it's required, we're happy to reproduce to him the Fraser log that he already has for the formality of doing so. But I think that for you know, an analysis such as whether this was without substantial justification or whether it was knowing and willful, the fact that, you know, this was happening literally on the day that they were deploying this new system, they printed out what they thought was the requisite log. And then it was, you know, doing the work of Mr. Fraser's much more detailed requests that kind of taught them how to give the more fulsome log. You know, that in a perfect world of having from Mr. Meadows, sure, but I don't think that there's any testimony or evidence that has been offered that would indicate going or willful, you know, effort to deprive Mr. Meadows of that information, or that they were acting without substantial justification. This is clearly, as we so often see with agencies, you know, an attempt to produce the right record that doesn't always go exactly as you know, would be ideal. The same would be true with the October 10th transmittal of the response back to open records at sos.gov instead of openrecordsc@gmail. Clearly a clerical error that is unfortunate. We did get the information to Mr. Meadows quite a bit later than would be desired, but again, you know, that is clearly a very obvious and easy to make clerical issue, not a knowing and willful.
Well, let me just press on that a little bit. So I understand we've got the, you know, just what is it that, other than, you know, a injunctive or some other equitable relief, the only other thing here that results from an Open Records Act claim is going to be fees and costs if it's without substantial justification. All right, that's one standard. But then I think there was also a request for the civil penalty that can happen as a fine. And the standard there isn't so much knowing and willful as it is just negligence, right?
My understanding is that under 74 that it's knowing and willful for the penalty.
All right. Well, let's put eyes on that again. I've got it up. I want to make sure I got that right since we're all here together. I'm looking at the sentence that starts with alternatively.
So it begins, subsection A begins with knowing and willful. And then, yes, you're correct. There is a provision for negligent violation. You know, we submit to the court that I think that you can tell from the testimony of Ms. Hill that this is an agency that, you know, has received, I think, 402 requests from this gentleman and has really, I think, bent over backwards to try to please them. The fact that out of these 402 requests, we've had a couple of technical inadvertent failures, don't think rises to the level of negligence that would support a penalty. And we would ask that the court decline to award one.
All right, and the specific kind of components that you're saying fell short, don't think they rise to negligence, but weren't perfect, for lack of a, you know, any other designation would be that in response to the September 18th request, it didn't include the 16 versus the 8, basically the difference between the Frazier production and his production. And then in response to the October 10th request, it's just the response went to the wrong email. That's where we just fell short of the line.
We would contend that, you know, that the agency has made every good faith effort to try to comply with a literally a barrage of daily requests from Mr. Meadows. And, you know, we would ask that the court take that into account in evaluating the conduct of the Secretary's office in these responses. And I think with that being said, we just ask the court take those things in mind in issuing a final order, and we're happy to provide the court with any additional information if during the or to provide any information that the court thinks we should have provided.
Okay, thank you, Ms. Young. And Mr. Meadows, you got the burden of proof, so I'll let you have the last word here.
The 402 requests barrage, other agencies handled that. Those 402 requests were never fulfilled. There are missing sequence numbers. There's problems. This is an opportunity for us to take corrective action. That's what I'm hopeful of for all Georgians, so that we can move forward and allow access, and particularly dealing with the standard operating procedures, so that those are in compliance with the Open Records Act. My goal is not to do inspections, believe me. That is the last thing that I want to do. I would rather just get the compliance and move on. And that's what I get from all the other state agencies. I just want the outlier Secretary of State to come into compliance. And thank you, Your Honor.
All right. Well, as I mentioned, other than the things I've already ruled on, I'll take it under advisement and have a written ruling to follow. And I'll just note a few things that may or may not make it into the order, but I'll say on the front end, Mr. Meadows, while, you know, I'm certainly sympathetic and even, you know, rooting for the cause of good government. I just let you know, I don't think I can use your, you know, by way of comparison, what the other agencies do. Every agency is different. Every agency's faced with a different, you know, set of challenges. And, you know, I know from my time at OIG that we didn't receive a fraction of what the Secretary of State's office did. If ever, there'd be months we'd go by without a single request. So, whereas I think, as has been established today, the Secretary of State's office is in a very different position. And so I think some awareness of that, the reality on the ground, is built into this statute. So when you come asking for, you know, what's reasonable and whether the response is sufficient, so much of this is going to be contextual. And I would say that if you are submitting requests on an almost daily basis, you're going to be increasing the odds that, one, errors are going to be made, and two, that they're not going to be found to be unreasonable just because they're trying to respond to everything that you have. And so if you're just trying to, you know, catch them in situations where you can say gotcha, and you think that's the best use of your time, then that's your right to do so. But whether that's going to be the best use of court's time, everybody else's time, that doesn't come without a potential downside for you as well. I mean, I'll point out the statute says not only can you be entitled to fees if they lack substantial justification, they could be seeking fees against you. So when you put in your pleadings that as a matter of law and you quoted a statute, that quote was nowhere in the statute about that they have to designate an open records officer. That's not how the statute reads, right? So I just point out that when you get to an impasse where you feel you have to resort to bringing this to the court system, just do that with the awareness that you better be sure you've got the winning argument, because that can also backfire on you as well. To that end, though, I thought that this compelled a hearing today because you did raise some issues, some discrepancies, some things that hadn't been decided as a matter of law yet. And this issue of the physical inspection, how it applies here, this issue of the open records officer, that wasn't something I could determine just on the pleadings and the record itself. And so we've had that record here. I'll parse through it, and I'll analyze it as best as I can determine the meaning from it, and we'll go from there. So with that, unless there's anything else for the record, that'll conclude. Take care.
Honor.
On a firm job, I ever saw.
Thank you, appreciate you. And Ms. Hughes, likewise, I appreciate you. You've literally been in my career.
I'm very sorry.
I feel my sincerity.
Yes, and I hope there won't be, but if there's another situation, I will make sure to reach out to you before.
I don't know who
Oh,
that
gosh,
was.
please.
I feel like I need to-
To the judge's point there, if
I also don't
collecting
want to see-
violations was my game, do it all day long. Part of it there, I used to be in your offices. I know, Chris. Oh, I think that woman slices bread and butters, and she is cool, man. I love her. Holy cow.
Somebody once told me that they thought I had. Office and said, because it is,
Because she laughs a lot.
you know,
You're proud.
it
I
is
don't
very
know her.
good.
She's clearly your person.
That's why you
You
may
have
be
a problem.
specific.
Oh, the
Some of the things
statutory
that they,
things with their
pass it
constitution. Attorney General Carr. Everybody's in a very difficult situation.
Well, I understand that they would hurt me, have I-
Constitutional conflict, because I'm usually got you over here.